Good morning. Please tell me your name.
Dion Noel.
All right, this is 21 CF 8840. Remind me, why did we roll this one? Oh, okay, that's right. Thank you. All right, sir, you're here charged with possession of cannabis with intent to distribute, possession of cannabis greater than 20 grams, possession of tetrahydrocannabinols, and possession of drug paraphernalia. I'm going to appoint an attorney to represent you. There is probable cause in this case, Counselor.
Yes, sir.
I'll stay the bond at $1,000 on count 1, $150 on 2 and 3, and $100 on count 4. You're not allowed to possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
All right, good luck, sir. Thank you. I couldn't remember why. Who's this?
I have a Spanish interpreter.
Okay.
Your Honor. Neris Garcia.
Got it.
Good morning, Your Honor. This is Teodoro Leal, Spanish interpreter. The interpreter has been previously sworn, Your Honor.
Good morning. Thank you. If you could please connect with a headset.
Thank you, Your Honor.
See.
Interpreter is connected to the podium, Your Honor.
Please tell me your name, ma'am.
Reina Linares.
Reina Linares.
21 MM 5224. You're here charged with battery, domestic violence. I'm going to appoint an attorney to represent you. There is probable cause in this case. Your bond is $500. You cannot have any contact with the victim. Do you understand what no contact means?
Yes.
You cannot possess a weapon of any kind, firearm or ammunition. I'll order you must maintain a separate residence and allow a one-time return with law enforcement to gather your belongings. Good luck, ma'am.
¿Puedo hacer una pregunta?
May I ask a question?
You can say anything you want. Everything you say is being recorded and can be used against you later. Do you understand that?
Sí.
All right, go ahead.
Solo quisiera saber cómo hacer para que esta persona con la que yo no puedo tener contacto o tampoco pueda tener contacto conmigo de buscarme en la propiedad de mi hermano o en la propiedad de mi papá. No sé cómo hacer eso.
Good morning, sir. Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
No es la primera vez que pasa. Cada vez que hay peleas, nos dejamos y yo regreso donde mis papás, pero él siempre me busca en cualquier lugar que yo esté.
Well, what I want to know is, about the case with this person that I cannot have contact with, if there's any way that he cannot have contact with me, because this has happened in the past. It's not the first time we have a fight. I leave him, but then he comes and looks for me when I go, say, to my dad's house to live. He's the one that then comes and looks for me.
So I understand what you're saying, but unfortunately, no. I don't have jurisdiction to order him to not have contact with you. So you'll have to talk to your attorney about what options you have, but this court doesn't have jurisdiction over him. I'm sorry.
Okay, muchas gracias.
Okay, thank you very much.
Good luck, ma'am. Is that it for Spanish cases?
Yes, Your Honor.
Thank you for your services this morning.
Well, welcome, Your Honor.
Vega. It's another.
21 CF 8905. Ms. George, I'm going to appoint your office to represent him.
Your Honor, I'll waive the appearance. However, I did have a PC challenge.
All right, go ahead.
In order to have an aggravated battery on a pregnant person, according to the Florida statute 784.045, a person must know or should have known that the victim was pregnant. If you read the arrest affidavit, it literally states that the victim found out she was pregnant 2 days ago. Nothing in the arrest affidavit states that he knew or that she was showing. or anything in the four corners of the arrest affidavit. So I will argue that there is no PC.
What says the state?
Your Honor, it's a domestic violence incident, which indicates that they were living together. One could surmise that he is the father of the child. And if that is the case, I would say that he probably did know as soon as she knew, Your Honor.
And Your Honor, I would just argue that he nor the victim is here to testify to that. We're solely basing it off of the four corners of this arrest affidavit, and nothing in here indicates that he knew or should have known.
You might be right, Counselor, about the part in the statute that says, and the offender knew, but what about, or should have known that the victim was pregnant? That they're in a relationship and they live together, should have known? How do we say that that's not there?
I'm arguing.
Or is there?
I'm arguing that we would not know because based on the four corners of this arrest affidavit, it does not state that he knew, he should have known. If she just found out 2 days ago, we don't know if it doesn't state that she was showing, she had a belly, she just found out 2 days ago, and that was it. We don't have any other facts that would indicate that he should have known that she was pregnant. Just because you're in a relationship doesn't mean the person tells you right away that they're pregnant.
I think you're absolutely right about that. But I'm still stuck on the should have known. You are correct. There's nothing in the affidavit that says that she told him or that he knew. The couple live together as a family unit. They've been in an intimate sexual relationship for the past 2 years.
Are you satisfied with the services of your attorney? Did you read the plea form in its entirety and review it with your attorney? And did you understand the form? On the plea form, it has a signature above
I pulled up the Florida statute, 784.045. If the person who was the victim of the battery was pregnant at the time of the offense and the offender knew or should have known that the victim was pregnant. I don't know if being in a relationship is sufficient for should have known, Counselor.
Oh, that's the victim, Your Honor.
Oh, that's the victim? Yes. Oh, all right, ma'am. Do you wish to testify this morning?
Yes.
Please raise your right hand to be sworn.
You swear to tell the truth, whole truth, and nothing but the truth, so help you God? Yes, I do. Please state your name for the record and spell your last name. My name is Ayat Mirza. Last name is Mirza.
All right, you can put your hand down. I'm going to let the prosecutor ask you some questions.
Good morning, ma'am. How do you know the defendant?
He's my fiancé. We live together.
Has something like this happened before?
No, never. We were out. He had a couple of drinks, and when he came home, he wanted.
I can't hear you at all, ma'am. I need you to get closer to the microphone.
We were out with some friends in Winter Park. We went to the wine room. When we came home, he knows that I'm pregnant for the past 3 weeks. And when we came home, we had an argument, and he had a lot to drink. He wanted to go for a drive. I told him not to. So he started just randomly talking. He grabbed his phone and called 911. So when he was on the phone, I got angry at him, and I took he had a pack bag. He was just angry with me. He did not lay hand on me or anything. The police, they came. They flashed the light on me. I have allergy and eczema on my hand and sometimes on my chest because I have morning sickness when I throw up, like my blood vessels. It comes on my face and my neck. So they assumed that he attacked me. I have never made any claim or said that he never laid hand on me. There were no physical altercation at all, 100%. We lived together and we continue. I was even he's the one who called the police, and he was angry that I'm not letting him out because he had to drink. But and he was outside shirtless, and they just handcuffed him and they took him. I tried to talk to the police that none of this happened. So the other officer, he said, this officer already made his decision. He's getting arrested, and you can come and see him tomorrow.
Okay. Are you afraid of him?
No, no, I want him back. I want to pick him up right now, and if there's a bond, I will pay it.
And while this case is pending, would you like to have contact with him?
Yes, we live together, absolutely.
Okay. And there's just one more thing I'd like to clarify. I think while you were explaining the situation, you said that he did know that you were pregnant?
Yeah, he does. Yeah, we live together. We're engaged.
I have no further questions, Your Honor.
Any cross, Ms. George?
No.
All right, thank you, ma'am.
Thank you.
Are you renewing your argument, Ms. George? Okay. I do find there's probable cause. At this time, his bond will be $2,500. He's not allowed to have any contact with the victim. He can't possess or consume alcoholic beverages, and he'll be subject to random alcohol screens. He can't possess a weapon, firearm, or ammunition, must maintain a separate residence, and I'll allow one-time return with law enforcement to gather his belongings. Good luck, ma'am. Please tell me your name. 21 CF 8911, you're here charged with robbery, false imprisonment, and battery. I'm going to appoint an attorney to represent you. Ms. George, did you wish to be heard?
Yes, Your Honor. I would argue no PC to the robbery charge. In order to have a robbery, there must be a taking from the person or custody of the person by force, violence, assault, or putting into fear. And then, of course, the property must be of some value, and the taking was with the intent to permanently deprive. However, here, if you look at the jury instructions for a robbery, it cannot be a taking that occurred as an afterthought to the use of force or violence. If it does, then it doesn't constitute a robbery but a theft. And here, if you read the arrest affidavit, it appears that my client and the victim got into an argument. It alleges that my client hit the victim and then afterwards, on the way out, took keys off of the counter. And this occurred after the attack had already happened. So I would just argue that there was no taking by force, and that the taking was a mere afterthought, thereby making the taking of the keys a theft at best, Your Honor.
All right, what says the state?
No objection.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, and put your hand down. Please state your full name and date of birth. State your name again, sir. Do you have an AKA by the name of Michael Faison? All right, counsel. Faison bonded or Francis bonded? That was Faison. Okay, I'll leave a chance now for denial on all three.
Doesn't the statute say from the person or custody of? Let's pull out the statute.
Correct, Your Honor, but it has to be by, I'm not arguing that part, I'm arguing the force, threat, or intimidation, and there was no force, threat, or intimidation. Again, it happened after the alleged battery had already occurred. And if you look, it says after the battery, she took the keys off of the counter. So I would argue, again, that the taking was not by force, threat, or intimidation.
An attorney with the public defender's office is present online to enter a plea on your behalf, and then the clerk will announce.
So the burglary with a battery PBL that is not charged here. In the course of that, the victim is able to escape. And on the way out, the defendant allegedly takes the keys off the counter, and that's not in the course of the burg with bat, which is what this is. It wasn't arrested as that.
Correct.
But that's what it is.
Correct, Your Honor. And if you look.
I don't know, let me.
If you look at the jury instructions again, Your Honor, it can't be a mere afterthought based on De Jesus versus the state of 98 Southern District. It states that if you have a taking of a property that occurs as an afterthought to the use of force or violence against the victim. So again, I will argue that that force or violence, the taking occurred after the force and the violence.
All right, so let's go back to the statute, 812.13, sub 3A. An act shall be deemed in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. If it occurs in an attempt to commit or in flight after the attempt.
There,
An act, and then B, an act shall be deemed in the course of the taking if it occurs either prior to, contemporaneous with, or subsequent to the taking of the property, and if it and the act of taking constitute a continuous series of acts or events. So you're arguing that this does not constitute a continuous series of acts or events?
no, I'm arguing that, and before you get there, you have to have a force, it must be taken by force, violence, assault, or putting in fear. So here,
Shoved in, hold on, let's read those words. It says, forced her way in the door. It says your client forced her way in, so there's your force.
no,
And no, that's force.
no, Your Honor, I think that for a robbery, you're taking whatever item you come in there with the intention to take that particular item from that person. So normally we'll see a robbery where you come in, let's just say it's by gunpoint, I point a gun at you and I tell you to give me the items, right? Or whatever, a knife, whatever the case may be. Here, what we have is a domestic violence dispute. And then after that battery occurred and the victim was crawling out of, I think it was like the window of the door or something like that, a window, I think. My client allegedly takes keys off of the counter. The taking of the keys off of the counter was not by force, it was not by violence, it was not by intimidation or anything to the victim, thereby making it a theft rather than a robbery. Her intent to go in there, if you read the arrest affidavit, was not to steal the items off of the counter.
We don't know that. Where are you seeing that?
Based off of, if you read the arrest affidavit, it does not appear she came into the house to take the keys off of the counter.
We don't know why she came into the house. She forced her way in to fight and argue, punched the victim numerous times, hitting her over and over again, slammed her into the wall.
I was the one slamming.
No, don't talk about the facts. Don't do that.
So your client's statement in the affidavit says, I think it's your client, yes. Dominique texted me and asked me to bring her keys and items that were left at my house the day before. So she was there about the keys, the same keys she took on her way out the door.
No, from what I read, she comes there. She was asked to bring the keys the items she left at her house, right?
Right, including keys.
Right.
Right.
Your Honor, but again, I will argue that even though she came there allegedly to bring back keys, the taking of the keys was not by force of the victim. The victim was already out of the house. So there was no threat or intimidation or force to take them from that victim.
Right, but the victim was already put in fear, is what I'm saying. I'm reading the statute, and it says, when in the course of the taking, there is force, violence, assault, or putting in fear. So we have all of those things in this affidavit. And then later in the statute, it says, in the course of committing the robbery includes in an attempt or in flight after, and if it occurs prior to, contemporaneous with, or subsequent to the taking of the property. So placing in fear, the battery, all of those things could happen anytime in this instance, and it could still be in the course of the taking.
I would argue, no, Your Honor. The purpose of a robbery, when you have a robbery, you're taking that particular item by force or threat or intimidation. So I come in and I'm taking, if it's money, if it's keys, my whole purpose of coming in here is to beat you to get those keys, is to point a gun at you to get your money. Here, we don't have that. We have a domestic violence dispute. The victim is leaving out of the house. And after the victim leaves, then the keys are taken off of the counter. So when the taking occurs, there was no force, threat, or intimidation. The battery already occurred. That's why if you read the instructions, it states that afterthought. If you have a taking that occurred as an afterthought to the use of force or violence, or threat of force or violence against the victim, the taking does not constitute a robbery, but may constitute a theft.
Which jury instruction is it? What number?
You're
Reading from?
15.1.
I think I understand your argument, but it sounds like you're making assumptions, because I'm reading the plain language of the statute, and what you're saying is, typically, when we see robberies, the facts look like this. That's accurate. That's a typical case that we might see. But it doesn't mean that this isn't a robbery if it fits within the plain meaning of the statute, which it sounds like it does to me. So that's what I can't get past, not what normal robberies look like.
No, no, that's not what I'm arguing, Your Honor. Literally, they have the case in the jury instructions that talks about afterthought. And you cannot have a robbery if the taking occurred as an afterthought to the use of force, violence, or threat of violence against the victim.
Wait, what's jury instruction did you say?
It says 15.1 robbery.
15, I'm sorry, I heard that wrong.
Part of jury instructions.
But I think also you're assuming something that I don't see in the probable cause affidavit. You're saying the reason for the force into the apartment and battery had nothing to do with the keys, but I don't think that's evident from the probable cause affidavit. I think you're assuming it's a domestic violence incident because there was violence. But she says part of the reason she went was because the victim asked her to bring the keys. So the keys are a central issue in the case. So hold on, let me get this jury instruction up. Do you have that case with you?
I do not, Your Honor. It was noted in the jury instructions.
In the course means the act occurred prior to, contemporaneous with, or subsequent to the taking of the property. Okay, so
Is present or to enter a plea on your behalf, and then the clerk will announce your court dates. And I'll enter denial.
So fear, violence, or assault, or putting in fear, I'm sorry, force, violence, assault, or putting in fear must be in the course of the taking. That's the element that is connected to in the course. So if there's fear, violence, assault, or putting in fear, force, violence, assault, or putting in fear, in the course of the taking means the act occurred prior to, contemporaneous with, or subsequent to the taking of the property. So if the act occurred prior to, so if the fear, force, violence, assault, or putting in fear occurred prior to the taking of the property, and that act and the taking of the property constitute a continuous series of acts or events, you're saying it did not.
Your Honor, I'm arguing that the taking was a mere afterthought to the battery. And if you read it, even when I'm reading, I just reread the facts of the case. She asked her to bring over her belongings. So it alleges that she forced her way through. They're fighting. Allegedly, she states that I'm going to kill you. She started fighting back. She said she pushed the screen out to get help. And so even as we continue to read, she's asking her to bring her belongings because at this point, it appears that they're breaking up.
Right.
So she's bringing her belongings back to the house. She forces her way in. However, the situation occurred when she got in. But it does, again, that nothing in here indicates that her whole purpose of hitting, fighting, forcing her way through was to steal the keys or to take the keys by force. This is a domestic violence dispute. They're breaking up. She's upset. They're upset with each other. And then we get down to the bottom where it says, one, Walker fled the bedroom. And then after that, she realized after, and it literally states that after the initial battery, she took the keys off the counter. And then she blocked her way, prevented her to escape, and it continues to go. And I would just state that, again, the keys were taken as a mere afterthought to the battery, thereby not being taken by force or threat or intimidation.
All right, I think I need to read that case. So can we bring her back?
Yes, Your Honor.
All right, what we're going to do is, after we see everybody, I'm going to read that case.
Okay.
I think I understand your argument, I'm trying to get there. So let me read that case. Oh, wait, what is that? Oh, this is the one. Where's that? Gordon?
Yes.
I got it. Yep. Please tell me your name.
Marcus Gordon.
All right, you're here at 21 MM 469, charged with violation of a domestic injunction. I'm going to appoint an attorney to represent you. Did you read this probable cause affidavit?
Which case is this, Your Honor?
This is Marcus Gordon.
Misdemeanor domestic.
Oh.
So I'll tell you why I'm asking. It says in the affidavit, it says they met with the complainant, later identified as Brian Gordon. Brian explained that due to ongoing issues between him and his siblings in the home, he sought an injunction against his brothers, Marcus Gordon and Christopher Gordon. The injunction was granted. Prior to my arrival on scene, both Brian and Christopher were informed by deputies that they were being served an injunction. Christopher complied, but Brian refused to leave. I think that's an error. Because then I made contact with Brian at the door. He went deeper into the home. When Brian was told he needed to leave, he responded by stating he's not going anywhere. I received permission to enter the home from Brian. Then it changes. Before entering the home, multiple attempts were made to call Marcus out of the home verbally. I opened the door and visually observed Marcus on the phone inside the room. I guess there's enough, because then it says Marcus again refused.
I think there is.
Okay, all right, there is probable cause. Your bond is $1,000. You can't have contact with the victim or witnesses in this case. Do you understand that? Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You can't return to this residence for any reason.
Excuse me, I'm sorry, I ain't trying to interrupt you nothing, but I have furniture and
I need you to speak louder.
I have furniture and all my possessions is there. I've been staying there over a year with my mom. My mom asked me to come stay there. My mom just passed away. So my brother just filed an injunction on me because
Talk about the facts. Don't talk about the facts.
Here's what concerns me, sir. You're out on bond for aggravated assault with a deadly weapon without intent to kill, battery, domestic violence, and an injunction was served on you, which is a court order, which you are refusing to comply with. That's my concern. I'll allow a one-time return with law enforcement.
And,
You're not allowed to possess a weapon, firearm, or ammunition, and at this time, I'm revoking your ROR in 21 CF 7901. Good luck, sir.
Your Honor, I would just ask that you take into consideration the fact that he has no other, his last conviction was in 2014, 0 failures to appear. As just stated by my client, he just lost his mother I think all of those play a factor in this. And I would just ask that if you're going to revoke his bond, as opposed to revoking and setting his bond at none, you revoke and double the bond, Your Honor.
I'm not inclined to do that, Counselor. Thank you. Good luck, sir.
Can't.
It was this one. I put it over here. Okay. Gotta read that case.
Your Honor, Chantel Diaz is medical.
21 CF 8897. Ms. George, I'm going to appoint your office.
I'll waive the appearance, Your Honor.
There is probable cause. She qualifies for pretrial release. Does the state object?
Diaz here, Your Honor, excuse me.
Oh, if the victim's here, let's bring the victim in. Good morning. Do you wish to testify? All
Yes.
right, please raise your right hand and be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record and spell your last name.
Guillermo Zea. Zea, Z-E-A.
I'm going to let the prosecutor ask you some questions.
Good morning, Mr. Zaya.
Morning.
How do you know the defendant?
That's my fiance.
Has something like this happened before?
No, not at all.
Are you afraid of her?
Not at all.
Do you believe that drugs or alcohol were involved in this incident?
No.
Should something like this happen again, would you be willing to call the police?
Yeah, but we never had an argument. It was just a dispute because I seen something on her phone, and I've been dealing with my father's passing. So I tried to leave out the house, and when we met up with each other, I went in front of her, and she ended up hitting my car, putting the car in drive. That's all that happened.
Okay. While this case is pending, would you like to have contact with her?
Yes.
I have no further questions, Your Honor.
Ms. George?
No question.
All right, I'm going to place her on pretrial release. I'll allow peaceful contact, no weapons, firearms, or ammunition. All right, good luck, sir. Thank you for coming.
Thank you so much.
Please tell me your name.
Eric Edwards.
I'm sorry?
Eric Edwards.
Thank you. A capias was issued for your arrest in 17 CF 8882 for failing to appear for a hearing on charges of domestic battery by strangulation and battery, one prior offense, domestic. There's no bond authorized on that capias, and I'll appoint an attorney to represent you. In 17 CF 15676, you're here for, a capias was issued for your arrest, charging you with aggravated stalking after a court order, 2 counts of violation of pretrial release condition on domestic violence case, and battery with a prior. There's no bond, and I'll appoint an attorney to represent you. All right, good luck. Please tell me your name.
Jeremy Fernandez.
21 CF 8912, you're here charged with 5 counts of sexual battery with a child by a person in familial or custodial care. 1, 2. And 2 counts of assault, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Does the state wish to be heard on bond?
Yes, Your Honor. As the first 5 counts are punishable by life, I would ask that the defendant be held with no bond.
Ms. George?
No argument, we reserve the right to have Arthur here, Your Honor.
All right. I will do that at this time. On counts 1 through 5, you'll be detained pretrial without bond. And I'm sorry, there's 3 counts of assault, not 2. I think I said 2. But on each of those counts, your bond will be $1,000 with special conditions. Even while in custody, you can't have any contact with the victim. Do you understand what no contact means?
Yes.
On 6, 7, and 8, You can't possess a weapon, firearm, or ammunition. You can't have contact with any minor child under the age of 18. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. Good luck.
Massey is downtown court.
Okay. So are we going to continue until tomorrow?
Yeah, sure.
I mean, they should do this downtown. If he's in court,
Yeah, I don't know why, but I would just ask to reset it for
all
tomorrow.
right. Please tell me your name.
George Padmore.
21 CF 8871. You're here charged with aggravated battery with a firearm, domestic violence. I'm going to appoint an attorney to represent you. There is probable cause here. Your bond is $5,000. You can't have contact with the victim or any witness in this case. Do you understand that? You can't possess a weapon, firearm, or ammunition. Were you guys living together? Okay, you can't now. I'm ordering that you must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. Do you understand?
Yes, ma'am.
You can't possess or consume alcoholic beverages, and you'll be subject to random alcohol screens. All right, good luck, sir. Oh. You want to just do that then? I hate for her to sit here the whole time. All right, let's call that one up. Isn't that supposed to be this are the 33 days in the morning?
Yes,
Oh.
in the morning.
Come on up, counselor. I don't want you just sitting.
This guy.
Yes, it is. I don't have a motion, though. Go ahead and put your appearance on record, counselor.
Nicole Phillips for statewide prosecution.
All right, are you here in Philippe Goutier, 21 CF 7202?
That's correct, Your Honor.
The defense has filed a motion to release him on his own recognizance, citing that it's been 33 days and the state has not filed charges.
Yes, Your Honor, state filed charges last evening. We have a receipt of the filed charges. It's going to be a consolidated case with 13 other defendants.
All right, so it was filed yesterday,
Yes, Your Honor.
so I should deny this motion?
Yes, Your Honor. And the state did not previously receive notice. They sent it to the state attorney's office, and that's why it was reset for today.
I understand, okay. I don't know if there's a way to know that. Like, how does the
We
defense
filed
know?
something called a notice of prosecutorial authority, and that goes to the clerk's office, so that should give notice that all paperwork should go to the statewide prosecution's office. This is not the first time this happens. This happens all the time.
All right, but you did file your notice?
Yes, Your Honor.
Okay, so maybe, Ms. George, you can make a note, maybe in the process, your office needs to check that.
Oh, no, I let the attorney know yesterday that he didn't send it to the statewide prosecutor, so it has been.
Okay, good, thank you. All right, thank you for coming, sorry to make you wait.
No, no worries. Thank you very much.
Sorry, I just want to get rid of those cases, because y'all get to stay with me, but there's no reason for her to sit. All right, what did you say about Tyree Pelham?
Tell him he's medical.
Thank you. 21 CT 533-678 and 21 CF 28913? No, 8913. Ms. George, I'm going to appoint your office in all of the cases.
I'll leave the appearance, Your Honor.
There's probable cause in all of them. On the misdemeanors, the bond is $500. On the felony, it's $1,500, no victim contact, no weapons, firearms, or ammunition, maintain a separate residence, one-time return with law enforcement to gather belongings. That's it.
Next, we have Flurema. He is also medical.
21 MM 5228. Ms. George, I'll appoint your office.
I'll waive the appearance, Your Honor.
Bond is $5,000, no victim contact, must comply with all previous court orders, may not return to the victim's residence or be within 1,000 feet of the victim's residence or place of employment. And I'm revoking his bond in 21 CF 8165.
Hits is also medical.
21 MM 5225. Ms. George, I'll appoint your office.
I'll waive the appearance, Your Honor.
Do you want to be heard on bond, Ms. George?
He does qualify for pretrial release, Your Honor. I would just ask for pretrial release in this case. He has no criminal convictions.
Does the state object?
No objection, Your Honor.
All right, I'll place him on pretrial release and require he post a monetary bond. I'll reduce it to $250. No contact with the victim, maintain separate residence, no weapons, firearms, or ammunition, one-time return with law enforcement. Please tell me your name.
Gary Angel Reyes.
21 MM 5229. You're here charged with battery domestic violence. I'm going to appoint an attorney to represent you. There is probable cause in this case.
Okay.
Don't talk about it. Your Honor, he does qualify for pretrial release. He has no criminal convictions here. I would ask for pretrial release in this case.
State.
No objection, Your Honor.
I'm going to place you on pretrial release and require that you post a monetary bond. I'll reduce that to $250. With special conditions, you can't have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings.
Yes, ma'am. Thank you.
Good luck.
God bless you guys. You have a great day.
You as well. Please tell me your name.
Marinessa Vega.
21 MM 5221. You're here charged with battery domestic violence. I'm going to appoint an attorney to represent you. There is probable cause. Is there a witness in this case?
No, Your Honor.
Okay.
And she does qualify for pretrial release, Your Honor. I would ask for pretrial release in this case. She has no criminal convictions here in Florida.
What says the state?
No objection.
I'm going to place you on pretrial release and require that you post a monetary bond. I'll reduce that to $250. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't return to that residence. Well, I'll order you must maintain a separate residence and allow one-time return with law enforcement to gather your belongings. You can't possess a weapon of any kind, firearm, or ammunition. Do you understand?
Yes, ma'am.
Good luck.
Thank you.
Brown is mental health.
These are out-of-county warrants, 18 CF 3472. Ms. George, I'm going to appoint your office in this case as well.
I'll waive the appearance, Your Honor.
There's no bond on these warrants,
Okay.
and they're very serious.
Joel Brandon, medical.
20 MM 29301. Again, they're out-of-county warrants. I'm going to appoint your office, Ms. George.
I'll waive the appearance, Your Honor.
He has bond. It's $1,500,
Okay.
but I'm still appointing your office. It's two different ones. You missed one. Please tell me your name.
Jalen King.
Leave your mask on.
You have a warrant out of Polk County, it looks like, for violating probation on 2 counts of racketeering, 2 counts of conspiracy to violate racketeering laws. There's no bond on this warrant. I'll appoint an attorney to represent you, and we'll notify them that you're here so they can transport you. Good luck, sir. Please tell me your name. You have a warrant out of Lake County 19 CF 2961 for violating your probation on a driving while license suspended charge. There's no bond authorized. I'll appoint an attorney to represent you and we'll notify them that you're here. I'm going to take no action on the out-of-bond case because I can't tell the dates. Good luck. Please tell me your name.
Estelle Miles.
You have several warrants from out of county. It looks like you have Osceola County warrant 12 CF 2042 for robbery, home invasion with a firearm, and grand theft from a dwelling. There's no bond on count 1, $2,000 bond on count 2. An 11 MM 3245, a warrant for violating probation for resisting without violence with no bond. We'll notify them that you're here so they can come and get you.
Ma'am?
I can't tell. Does she have another one?
No, ma'am. Ma'am?
Just a second. Yes.
This case, I did contact an attorney, and he's been attempting to communicate back and forth with the prosecution for Osceola County. There's been no information on this case whatsoever. Only information that was updated, I just recently received my license. Now, during the course of all of this, I went so far as to open a legitimate business, and I have not been in any sort of trouble since 2009. If there's any way we can assist some sort of bond.
I can't do that because this is out of another county. So you're going to have to go to Osceola County and ask that judge to give you a bond.
So with that being said, is what's the layaway time as far as the transit over there? Because the first is literally around the corner, and I don't want to lose everything.
Right. COVID slowed everything down. They were much slower to transport during the coronavirus, but everyone is back to transporting, and I think it'll happen pretty quickly because it's in Osceola.
Is there a chance that it could happen sometime today?
I don't know the answer to that. It's up to Osceola County. They're the ones that have to come and get you and take you there. So call your attorney. I'm not going to appoint the public defender. You have an attorney. Call your attorney today and tell them that you're here in Orange County.
I've been calling him since I got
Okay,
in
good.
here. Is there any chance that I can get assistance from a public defender until I'm able to make contact? Because I'm out here alone, and I've been.
Well, so that's not how the public defender works. You have to qualify for it.
So what would make me unqualified for?
It has to do with money. Right now, there's an admin order because of the pandemic that everyone gets appointed the public defender, but you've already told me that you have a private attorney.
Yeah, and he's been helping me with child support and the entire spectrum of what's going on.
Is he helping you with these cases?
The only thing that he was able to tell me is that he's tried to contact the prosecution's office to have the case canceled out because there's been no activity on the case for over 9 years. And it's not as if I hid. My house is in my name. I have a driver's license. My company that I opened is in my name. I never hid. You know, I never put myself in a position that I was unattainable for them. In fact, as soon as they pulled my address and came to my home or stopped me, I was very cooperative because this is nothing for me to.
All right, I'll appoint the public defender's office. That's here, and you got to go back to Osceola, so.
Yeah.
Yeah.
All right, good luck, ma'am.
Thank you.
Please tell me your name.
Rhoda Star Vanderstar.
MM. 20002483. A warrant was issued for your arrest out of Polk County for failing to appear on a criminal mischief charge. The bond is $500. All right, good luck, ma'am.
Can I please speak, Young?
You can say anything you want, but
I know, but can I please speak? Because I pled guilty, and I had a plea, and I didn't show up for that because I was in the hospital. So the judge has, on August 6th, I'm supposed to go before the judge to get it lifted with my medical records that I'm supposed to bring. On August 6th, I have a judge, I'm supposed to meet with a judge.
well, you have a bond on this. They're not asking to hold you at no bond. So if you don't post the bond, you'll be transported there. But if you do post the bond, then you have to go in front of that judge on August 6th.
Yeah, but August 6th was to shoulder my proof of being in the hospital, because that's the only reason why I didn't go to the plea. I want to get done with this.
You would still have to show up to that court date then.
Yeah, oh, I do?
Yeah.
Okay, so, I mean, to show them that?
Right.
I just thought, can I get out today?
You can if you post your bond.
Oh, well, so I'll have to wait till I get paid tomorrow.
I'm sorry, what?
I have to wait till I get paid tomorrow.
That may be, but you do have a bond. So if you can post the $500 bond,
Is it $50 then?
that's between you and a bondsman.
Oh, do I have to get a bond, or what if I pay out of my pocket?
You can do that too, but I can't,
Is it 10%?
I can't be involved in that. That's between you and a bondsman,
Oh, so, but I have to have a bondsman.
unless you post all of the bond yourself.
So also, unless I pay all 500?
Yes, I think so. All right, good luck, ma'am. Please tell me your name. A warrant was issued for your arrest in 20 CF 9220 for violating your probation by changing your residence without first procuring the consent of your probation officer, by failing to live without violating any law, in that you were in possession of a drug or narcotic as evidenced by a urine sample. There's no bond authorized on this warrant, and I'll appoint an attorney to represent you. Good luck. Please tell me your name.
Sami Kusina.
A warrant was issued for your arrest in 20 CF 1360 for violating your probation by committing the criminal offense of burglary with assault or battery on June 11th in Leon County. There is no bond authorized, and I'll appoint an attorney to represent you. Good luck. Please tell me your name.
Austin Tweed.
A warrant was issued for your arrest in 18 CF 5322 for violating your probation by committing the criminal offense of trafficking an MDMA with a weapon on or about July 6th in Seminole County, and the criminal offense of possession of a firearm by a convicted felon also in Seminole County. There's no bond authorized. I'll appoint an attorney to represent you.
I have an attorney.
You have an attorney? Yes. Okay, I'm not appointing one then. Hold on, there's additional violations. Committing the criminal offense of grand theft, possession of alprazolam, and possession of a controlled substance. It looks like they were all part of the same arrest.
Yeah.
So just get in contact with your attorney.
Yeah, we were here 3 weeks ago, remember, and we got a bond, and then.
That's right.
Yeah. I bonded
Yes.
out, and then she violated me, so,
Well, good luck.
yeah. Appreciate it.
Yes, sir. I knew he looked familiar. Please tell me your name.
Jerusalem Lamont Williams.
You have a warrant for your arrest in 19 CF 6748 for violating your probation by committing a new law violation, possession of cocaine in Orange County on July 20th. There is bond. It's $5,000. I'll appoint an attorney to represent you. That's the only one I have here. Okay. Good luck. Yes, sir.
So the one, when I first got arrested on a no bond, that's how.
Well, that may be a different case. You have different cases. I don't know.
No,
This
it's the same
case, your bond is $5,000.
Okay, so I'll be able to bond out?
Yes.
Okay, thank you.
Good luck. Who's that?
Rara. He
Wait, what's-
showed up
Who?
from medical.
Okay.
Research?
What's his name? Tell me your name.
What's your name?
21 MM 5228. Wait, what? Oh,
Showed up, Your Honor.
all right. Is the witness here?
No, Your Honor.
Oh, he showed up.
He showed up. But it
Oh, so we already did this, but he wasn't here.
Right.
I was like, why does this look so familiar? I'm sorry. Okay. All right, sir, I appointed an attorney to represent you. Your bond in this case is $5,000. You can't have any contact with the victim in this case. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You can't return to the scene of this offense or be within 1,000 feet of the victim's residence or place of employment. Do you understand that? Did you say yes?
Yes, ma'am.
And then in 21 CF 8165, I revoked your bond. Good luck, sir. All right, we need to,
Yes, hello. Yes,
good morning, sir.
good morning.
We're trying to get an interpreter.
Oh, sure, sure. Can I testify? I'd like to testify for my wife.
I'm sorry?
I would like to testify, actually.
Okay, let us first get the interpreter,
Oh, no, I speak English.
but it's for her.
Oh, yes, yeah, of course, of course.
Does your wife speak English?
No, she speaks a little.
But her primary language is Russian?
Primary language is Kazakh, but she also speaks fluently Russian. Yes.
English I speak only a little bit, yeah.
Yes, just,
60%.
yeah, like, maybe like, intermediate or lesser, like pre-intermediate level.
All right, let's get the interpreter because I want to make sure she understands everything. This is 21 CF 8884. Ms. George, I'm going to appoint your office in this case.
Балачка.
Hello, this is Judge Gibson. Can you hear me?
I can hear, but not clearly.
Are we on speakerphone in your office?
In whose office? My office or your office?
Your office.
I have a headset, ma'am. I hear static from your side.
Is it clearer with the headset?
I'm sorry, I have a headset. I hear static from your side.
So with the headset, can you hear and understand me?
Let me transfer to another interpreter.
Hello, I understand you're looking for a Russian interpreter for a court. Is that correct?
Yes.
Thank you. Please hold for your legal Russian interpreter.
Thank you. So this has never happened before.
To hold for the next available interpreter.
What other language do you speak, ma'am?
That's it. Russian, English, little bit. That's it.
Okay. Is there an interpreter on the line now? What is happening? Hello, can anyone hear me? Can you hang up?
When they speak. But my husband will stand up. I need some translator.
I'm sorry, this has never happened before. English? All right, ma'am. Can you tell me your name?
My name is Assel. Assel.
And what is your last name?
Najmetdinova. It's pretty long.
You're here because you were arrested for aggravated assault, domestic violence. Do you understand that?
Yes.
I've appointed an attorney to represent you. There is probable cause in this case. Sir, you told me you want to testify, do you?
Yeah, I would like to drop all the charges.
Well, hold on. Before you keep going,
Yeah.
I need you to raise your right hand and be sworn.
Yes. Yes.
Do you swear to tell the truth,
Yeah, I swear to tell the truth,
whole truth, and nothing but the truth, so help you God?
all the truth, and
State your name for the record. And
yes,
spell
my
your
name is
last-
Elmar. Elmar, Elmir, first name, and last name Duisekeyev, Duisekeyev. I'm a victim and her husband.
You can put your hand down. Thank you.
Yes.
The prosecutor wants to ask you some questions.
Yes.
Hold on, let me ask. So far, do you understand what we've done? Do you understand?
Yes, yes. Yes.
Okay.
So you already stated that this is your wife, correct?
Yes, she's my wife, yes.
Has something like this happened before?
No, never happened.
Are you afraid of her?
No, I'm not afraid of her.
Do you think that drugs or alcohol were involved in this
No,
incident?
she never consumed drugs or alcohol.
While this case is pending, would you like to have contact with her?
Yes,
I have no
of course,
further questions,
absolutely.
Your Honor.
And
Thank you. Hold on. Let me ask the defense attorney. Do you have any questions?
No, Your Honor.
All right, sir, is there more you want to tell me?
Yes, I would like to tell more. I really want to have contact with my wife. I'm not afraid of her. This is all big misunderstanding. And I want you, please, could you release her on a low bond, please? I'm begging you.
All right, thank you.
Your Honor, she does qualify for pretrial release. I would ask for pretrial release in this case.
Ma'am, I'm going to release you on pretrial release, which means you do not have to post a monetary bond today. Do you understand?
No.
Pretrial release is a program.
Can I explain?
You'll be Yes?
Yes. Жанна, получается, тебя выпустят без суда, сразу без залога.
Okay, understand.
You understand that?
Yeah.
So there is a charge for the program, but it's not bond today.
Okay.
That's good.
It's a low charge.
Low charge, right?
Yes.
Okay.
Because your husband came and testified, I will allow you to have peaceful contact with your husband, and I will allow you to return home.
Oh, thanks God.
you so
You
much.
understand?
Yes, I understand. Thank you so much.
But you cannot possess a weapon, firearm, or ammunition. Do you understand that?
Yes, understand.
No knives, no guns, no weapons.
Yes.
You understand?
Yes, sure.
Are there any other conditions the state would request?
No, Your Honor.
Do you understand everything I said today?
Yes, I understand everything.
Do you have any questions?
No, I just want to say thank you so much.
Oh, you're welcome. I just wanted you to know that everything you say today is being recorded and can be used against you later. But good luck. Thank you, sir. Good luck.
Thank you, Judge. Thank
She'll
you.
be released at some point today, but they have to process her out. I don't know how long that will take.
Okay. Thank you so much.
Yes, sir. Good luck. I don't like doing that without the interpreter, but she could understand, so. I need to just read through this really quickly, and we'll call Belcher back up. If you want to go ahead and bring her in, B, so that we can, I want to discuss this, but we need her in here.
Gosh darn it.
You are Tijuana Belcher? All right, this is 21 CF 8911. I'm reviewing the case law provided by your attorney, DeJesus v. Florida, 98 Southern 3rd 105, and then Davis v. Florida, 922 Southern 2nd 438. All right, so, Ms. George, here's what I'm seeing. In the DeJesus case, which quotes the 5th DCA case, Davis, the court, both courts have said, because the 5th DCA said that okay, well, the issue is the defense asked for a special jury instruction to cure what they perceive as a defect in the standard instruction. And it looks like the 5th and the 4th DCAs agree with that. And that has to do with the language that you talked about earlier. If the evidence shows that the taking of property occurred as an afterthought to the use of force or violence, which resulted in in this case, death of the victim, which not in our case, the taking does not constitute a robbery, but may still constitute a theft. The 5th DCA reversed that robbery conviction and remanded for a new trial because the trial court refused that jury instruction. It says the defendant was entitled to instruction on afterthought. But it doesn't say that if it's an afterthought, that means there's no probable cause for it to be robbery. The instruction is ordered to be given because it's a defense to the charge of robbery. So you're arguing that that means there's no probable cause in this case?
But I am, Your Honor. I would argue there's no probable cause because, again, I would argue that the taking of the keys was not by force, violence, assault. My client came over to deliver items that were at her house, that was left at her house, i.e. they were having a breakup. In the midst of that, they got into a scuffle, an argument, they started fighting with each other. Allegedly, my client wouldn't let the victim leave. So the victim somehow gets away and climbs out of a window, gets help. After she leaves the house, the keys are taken off of the counter and she leaves.
And the state agrees there's no probable cause for robbery?
When I read it, Your Honor, I thought that it was a theft. I actually thought that it was in furtherance of the false imprisonment.
Which
to prevent
would
her
make it a
from being
robbery then?
I'm sorry?
Which would make it a robbery then?
No.
Both the 4th and the 5th districts have determined the standard robbery instruction is not adequate to explain taking property as an afterthought. So in the Davis case, the court says, no, it's a different case. It's in Perkins. No, Mon, holding that the state failed to prove a robbery because the evidence established that after the violence, the defendant took the victim's belongings, quote, to effect his escape from the scene. I'm sorry, Ms. George, go ahead. I just wanted to finish that because I was reading it.
And then if you look at De Jesus, Your Honor, on the second page at the bottom, it distinguishes, it says one of the differences between robbery and a theft is that the robbery is in a course of taking, there is the violence, the assault, the putting in fear. However, if the force or violence is motivated by a reason other than to rob the victim, then the taking of the property would not constitute a robbery. And again, I would just argue that they are having a domestic violence dispute. They're breaking up. There's the false imprisonment. There is the battery. However, there is nothing to indicate that her whole purpose was to come over and rob the victim.
All right, considering all of the case law, weighing that against the facts in this case, I still think there's probable cause for a robbery. However, I will find probable cause and still release your client on her own recognizance on that charge. Your bond on count 2, the false imprisonment, will be $2,500, and count 3, the battery, will be $100. You may have no contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You can't return to her residence or place of employment for any reason. Do you understand that? Are there any other conditions the state would request?
No, Your Honor.
All right, good luck. Any other business before court is in recess?
Nothing
No,
but
Your
the
Honor.
insurance.
Yeah, so we have one Spanish defendant, we gotta wait till 1 o'clock to deal with them.
1 o'clock.
All right, good afternoon, sir, can you tell me your name?
My name is Robert. That's my first name, last name Dumas, D-U-M-A-S.
All right. Sir, you're here for arraignment in case 2020 CT 512 AA on charge of driving while license suspended. That is a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. State, do you have an offer you want to resolve this case with?
Both this one and the next case, Your Honor, is an adjudication of guilt and credit time served.
I'm sorry. You're also here in case 2020 CT 604 AA on charge of driver license suspended, and he had an open case as well.
Adjudication of guilt, credit time served. I don't know if it was called up, Your Honor.
Yeah, anybody remember his face sheet from the other day? From Tuesday?
No, we won't have his face sheet, but I can do a copy of his criminal history.
No, on the face sheet, there was a third case that was open. It was a notice to appear case. And I was trying to see if we can resolve that case as
I don't
well.
have access to the face sheet because it's,
But you don't have access to the face sheet from the other day?
not the face sheets from previous days.
Yeah.
I don't have access to that.
I think we can pull him up. He was arrested, I think he was here on Tuesday.
You said he had another case?
11/5/1969. Yeah, there were 3 cases. Like, he was arrested on 2 of them, and it was an open notice to appear case. I was trying to see if the state had an offer to resolve all 3 cases.
For Robert Dumas?
I believe so. He was here Tuesday, right? He's the gentleman that was here Tuesday?
Yes, Your Honor.
He got booked in on the 26th.
Yep, and I saw him on Tuesday, correct? Yeah, saw him Tuesday.
No, he didn't have an open NTA case.
No, Pascal, that's Pascal.
So that's
The third number is 20 CT 4275.
2020 CT 427.
Sir,
I don't have that one. And he's in, okay. Because I know he's on probation in Pasco, but he's saying some of these occurred before.
Yeah, this is old stuff from, I don't know when you started your probation.
But does he not have a bond on the other case? I don't know.
I think on one case he does not have a bond. If I remember correctly, he had a bond on one case, he didn't have a bond on the other one.
that was, day before yesterday.
Yeah, that's when I saw him the other day, and then,
He don't have a bond on the 604.
right.
The one that we're seeing today.
Yeah, so 604 AA, he doesn't have a bond, and then 5212 AA, he did have a bond. That's why I was trying to see if he wanted to resolve his cases on Tuesday.
Okay, okay, this, in the effort of clarity, because last week, I
Correct.
went to Pasco County.
Correct.
Because I got a citation for driving with a suspended.
Correct.
And when I went to court, I informed the judge that I had as a matter of fact, I didn't inform the judge because I was confused. So when they sentenced me to misdemeanor traffic probation, when I went to probation last Wednesday, I informed her, ma'am, I don't understand how I'm being put on probation, and I've got 2 outstanding warrants in Orange County. That's when she called Orange County. Orange County said they would come pick me up.
Okay.
I just wanted to get it all straightened out. And
Okay.
then I got here, and one was a bond and one was not. Now, in January, I instant the $100 instant bond. I don't know which case that was. And I thought my date was 4/2/221, but it was 2/4. So I failed to appear on that. And by the time I got the letter, so it's just, I don't know which cases are which, but I would like to resolve the one that's no bond so that I can bond out on the other one.
I mean,
got one today, the one that I'm,
That seems to be nonsensical. You might as well resolve all 3 cases. That way you don't have to worry about coming back to Orange County. You can just deal with whatever you got going in Pasco County. Because if you want to resolve the no bond case, you still gonna have court dates here. You're still gonna be facing time here, and further suspensions of your license here. So
Yeah, I don't know how many he has, Your Honor. Driving while license suspended, and I don't want him, if he's not already habitualized, to plea out to all these charges.
do we have a driving record in any of these cases? Or somebody give me a driving record?
So he's okay with paying the bond, we just want to plea out the one with no bond.
Yeah, but I mean, if he already has, he's already on probation for a driverless suspended case, I don't know how many prior driverless suspended cases, so
Correct.
even the plea to this one case could still,
might have this.
you're still concerned and still not, maybe realize that your license will be suspended for the next 5 years.
Okay.
So if you're a designated habitual traffic offender, I think Ms. Davis can pull me up a driving record.
Mm-hmm.
Right. I think the clerk has had 2 green light situations since the beginning of the year already, so.
Yeah, and I signed up for one, and I actually called and with the clerk of the court and had a appointment to come and rectify some of these in his or her chambers, and it got canceled due to the spike in COVID or whatever.
Yeah. All right. I see one from Pasco, which was from June of this year. And you picked up some other, it's a criminal failure to appear on the citation, so you D6 your license on, I think probably these 2 cases. All right. So yeah, so if he pleads to all 3, then yeah, he'll probably become a habitual traffic offender unless the state's willing to amend one of the charges.
Did you want to show me that?
Yeah,
If I may approach?
yes, sir.
And we can plea it out. Mm-hmm.
They're all driver licenses. Is that last one, the 4275?
Because a withhold, I know.
I thought it was a withhold.
No, art. Your Honor, just for clarification, the withhold is still going to habitualize him.
Yeah, I believe so.
It would have to be amended to a no valid.
Correct.
Okay. Okay, perfect. We'll do that. Your Honor, so what we're going to do is plea out to 2020 CT 604. I think that's the one he's being held on no bond, and he's going to go ahead and work on getting his driver's license for the other case. The state's
Does
not-
that state what you're offering, or?
Yes, Your Honor, I have no objection to that.
All right. All right, sir, raise your right hand and be sworn in. Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God? All right, sir, you're here in case, you can put your hand down. You're here in case 2020 CT 604AA on a charge of driver license suspended. That's a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. Do you understand that?
Sir.
What plea, Miss, it says I'm attorney, I believe I appointed the public defender to represent him on Tuesday.
Okay. We're going to enter a plea of no contest, Your Honor.
All right. All right, Mr. Dumas, you understand by entering a plea of no contest, you're going to waive all the rights outlined in the plea form that's in front of you.
Yes, sir.
You understand that a conviction in this case at a later date can be used against you to enhance your sentencing up to a third-degree felony.
Yes, sir.
Are you under influence of any drugs, alcohol, medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, you could be subject to deportation.
Yes, sir.
Did the party stipulate to a factual basis?
Yes, Your Honor.
Yes, Your Honor.
All right, sir. The court, based on the stipulation, is going to find a factual basis for the entering your plea, as well as I reviewed your driving record in this case, and do find a factual basis contained therein. I'm going to accept your plea of no contest, find your plea is freely and voluntarily entered. I want to adjudicate you guilty of the charge, give you credit for the 4 days in the Orange County Jail with 4 days credit time served. The court costs and cost of prosecution in this case are $306. There's a $50 public defender application fee and a $50 public defender lien. I'm going to make all these costs payable directly to the clerk within 2 years of today's date. You have 30 days from today's date to appeal your judgment and sentence in writing. Do you understand?
Yes, sir.
All right, and then I was gonna put a PD on all his cases, 2020 CT 512AA and 2020 CT 4275 AO. And let's get court dates and pretrial trial dates. I'm sorry, Ms. George, you enter pleas not guilty?
Yes, Your Honor.
All right, you're gonna enter pleas not guilty on those two cases and get them for pretrial and trial in those divisions.
Division 61, 512AA. Division 61, pretrial conference will be August 30th at 9 a.m., courtroom 6B.
Where is 4275?
I only see that.
Where is 4275? Is it in 61?
Oh, no, it's in 80.
Can we move, this move it to 61, it's a lowercase number, it's in division 61. So you have the same court dates.
2020 CT 4275 will be moved to Division 61.
Yep.
The same pretrial conference.
All right, so you got those dates? Did you write them down for him, Mr. George?
You said August.
30th, 9 a.m., 6B.
All right, so you got your court dates in writing. You also have an attorney appointed to represent you in your two cases. So you really don't have no excuse to miss any more court dates.
No.
All right?
Thank you. So I can just go now?
Yep, you can, all right. Have a great day, sir.
Sarah Dorr.
Yes, sir.
Refused court.
Okay. This is 2021 MM 4646AO. Ms. Doyle is represented by the Public Defender's Office. You want to waive her arraignment?
Yes, Your Honor, I'll waive and enter a plea of not guilty.
Number 7 for pretrial and trial in Division 84.
Division 84, pretrial conference, August 9th, 9 a.m., courtroom 4B.
And good afternoon, sir. Can you tell me your name?
Gonzalez, Stephen.
What's your first name?
Stephen.
All right. Mr. Gonzalez, you're here in case 2021 MM 4214AO on a charge of battery. That is a first-degree misdemeanor. It's punishable up to 1 year in the county jail and a $1,000 fine. Do you understand that?
Yes.
You're represented by the Public Defender's Office in this case. Ms. George, what plea you want to enter on behalf of your client?
Not guilty, Your Honor.
Sir, I'm going to accept your plea of not guilty in this matter. I'm going to set you for pretrial and trial in Division 84 Division 83 on the following dates.
Sir, can I ask a question?
You can talk to your attorney because everything you asked me is on the record. Hold on, wait. This is you have an attorney? You represent public defenders. The Office of the Public Defender represents you, so you do have attorneys representing you. Yep, cover your nose for me, though. Wait. Female defendant after him, so I'm trying to figure out who is she, because I have one bunch of guys. There, move up listed. All right, if that's Ms. Torres behind this defendant, we're going to do her at 1 o'clock. 1 o'clock. Have a great day, Mr. Gonzalez.
All right, thank you.
We weren't given the dates, Your Honor.
Did we give him dates for 83?
Pretrial conference day will be August 16th, at 8:30 a.m., courtroom 6C.
There it is. August 16th, 8:30. All right, have a great day, sir.
Jimmy LeGree, behavior.
All right, this is 2021 MM 325AA. Mr. LeGree, I want to appoint the public defender to represent him.
I'll waive the appearance, Your Honor.
All right, we're going to, he's here on a charge of trespass on property other than a structure, conveyance, refusal to leave, reviewed the charging affidavit, did find probable cause for his arrest. Has he been screened for mental health pretrial in the past?
Talking about John, correct?
The Jimmy LeGree.
Oh, hold on. Not that I'm seeing, Your Honor.
Okay. All right, I'm going to release Mr. LeGree on mental health pretrial release in this case. If he doesn't qualify for mental health pretrial release, it's going to set his bond at an amount of $50. Condition on his bond not to return to the scene of the location and not have any contact with any victims or witnesses. I'm not going to take any action on this out on bond cases 2021 MM 3812, 2021 CF 3023, 2020 MM 358AA, and 2016 CF 1456AO. the 2020 MM444AA.
Alfredo Rivera, behavior.
It's 2021 MM5222AO. Mr. Alfredo Rivera, want to appoint a public defender to represent him.
I'll waive the appearance, Your Honor.
All right, did review his charging affidavit on the charge of battery, did find probable cause for his arrest. Going to set his bond amount of $1,500, condition of his bond, no contact with the victim, no return to the scene of the location, no weapons, no firearms. Any weapons or firearms he has need to be returned to law enforcement within 24 hours of his release.
How you doing, sir?
Hold on. Good afternoon, sir. Can you tell me your name?
Ollie Russell. I just want to see if I can go get out. You know.
Oh wait, one second.
I just got out for the same charge.
That's what I'm saying.
Slow down.
I'm not in charge for this.
Slow down.
Russell.
There we go. Mr. Russell, you're here in case 2021 MM5210AO on a charge of trespass on property after warning. Did review the charging affidavit in your case, did find probable cause for your arrest.
I've already
wait, hold on.
trespassed. They let me out. It's been like 2 weeks, and I want to see if I can get out.
As to the,
Get out today.
stop, please.
Yes, sir.
Because you can't talk and I talk at the same time.
I said
Because
yes.
wait, let's see, still talking. There's a lady downtown taking down what we're saying. And if I can't communicate and making sure the record is clear, then we're gonna have a little issue this afternoon. All right? So just wait. Because when I address you, then you can answer my questions, and then we can make sure we can try to get you out of here as soon as we can. State, is there an offer as to the various trespass cases that he has open?
Adjudication of guilt, credit time served, and no return to 455 North Garland Avenue, Your Honor.
All right. He has, that's what I'm saying, he has 1, 2, 3 other trespass cases. Are they all from the same location?
I did not notice that, Your Honor.
He has,
Yeah.
competency.
That was my next question.
Yes, Your Honor.
All right. And was he just ROR last time, or has he been screened for mental health pretrial release?
He's been being screened for mental health PTR since March 30th, 2021. And each time, our mental health specialist says defendant does not meet the criteria for mental health PTR.
What's the criteria?
You want me to print it out for you?
Yeah, I'm just curious as to what criteria. I mean, he falls, looking at his history, he falls squarely under the admin order. So I'm trying to understand what about, I mean, he doesn't seem to be in a state of psychosis, so. What case is Mr. Thompson here for?
Oh, yeah.
All right, you can come around. Later.
He's coming around.
Can I keep this? All right. All right, Mr. Russell, I'm gonna set you, let me see.
Yes, I'm listening.
All right, I want to set your bond in this case amount of $50. Condition your bond not allowed to return to the scene of the incident and have no contact with any victims or witnesses.
Yes, sir.
Want to appoint the public defender to represent you in this case. Ms. George, you may want to look into why they keep rejecting him from, I'm going to send an email and ask them, but why they keep rejecting him, but based on his history.
Till I can get out of jail?
All right,
I'm just asking.
I'm not sure.
Do you know if it's today?
It's probably not going to be today. All right, Ms. George, you may want to look into that because he seems to be,
Yes, sure.
doesn't have violent history. You know, seems to be the people we're trying to capture underneath that program.
Thank you.
Have a great day, sir. Yeah, no action on out on bond cases.
He's here for Mr. Levere. Jameson, how you doing?
How you doing? Who?
Yeah, Jameson Levere.
Dude.
Well, I'm not sure if I'm early or late. It's on Mr. Jameson.
Early. Look, no.
Jameson Levere. Yeah, you're early.
Hold on.
Good, how are you? I was here when you came the last time.
All right, yep, got it. All right. Who's this?
I'm sorry. No, I'm okay. We can go right into it.
All right, well, let's deal, we already got this gentleman in here, so let's deal with him first, and then we'll get to Mr. Laguerre. Good afternoon, sir. Can you tell me your name?
Robert Michael Gillum.
Sir, you're here in case 2021 MM 48640 on charges of pay theft. I did review the charging affidavit. In this case, I did find probable cause for, actually, there's a warrant issued for your arrest in this case. Judge issuing that warrant did find probable cause for your arrest. Gonna stay your bond in the amount of $500, condition your bond, no return to the target, and no contact with any victims or witnesses from this case. Check one thing. Seems you're out on bond in the case 2021 2021 CF 3548 AO. The court's going to revoke that bond, going to set you a new bond amount of $5,000. Condition that bond that you not possess or consume any drugs or alcohol without a valid prescription. You not associate yourself with any known drug dealers or drug users. In that case, we're going to appoint a public defender to represent you in your new case. You have a great day, sir. All right. Good afternoon, sir. Can you tell me your name?
Name is Jameson Laguerre.
Mr. Laguerre, you're here in case 2021 CF 80970 on charges of possession of a firearm by convicted delinquent and possession of ammunition by convicted delinquent. The judge signed your warrant. In this case, has already found probable cause for your arrest. Mr. Counsel, you want to put your name on the record?
Yes, Your Honor. Harold Thompson on behalf of Mr. Laguerre. Your Honor, from my understanding, he's already out on bond for this particular case. And
No, it's a separate case.
It was something that is.
They went to
stemming from the
arrest
same
him on the
incident?
warrant that he's out on bond for, and then when they found him on that warrant, they found pure probable cause to charge him with more guns. So the warrant that he was out on bond on for is 2021 CF 5809 AO. That case had a warrant. They went to arrest him, found more guns, and then they didn't charge him immediately with it. They did as an add-on charge. Got another warrant for his arrest as to that. So in this case, it's going to stay your bonds on the warrant amount of $5,000 in count one and $100 in count two. Condition of the bonds is you're not allowed to possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm not going to take any action on your 2021 CF 5809 AO case because it's happened it's the same day of your
That's what I
arrest,
was
so you weren't
hoping.
out on release yet when that
Thank you.
happened.
Thank you so much.
Thank you, Your Honor. I believe that's it for me.
But you are extremely young,
Yes, sir.
and like I'm trying to tell some of your other fellow young people that come in here, you have to up the value of your life. You understand me?
Really changed.
All right, let's listen to me. You've been through the juvenile system.
Sir.
See how that works?
Sir.
All right. It works sometimes it doesn't. But now you're an adult. The state of Florida has a price, all right, on your life. They know exactly how much it's going to cost to house you for the rest of your life.
Sir.
All right?
Yes, sir.
So you may want to raise your value of your life above that amount. That way you don't have to spend time here with me or in the Department of Corrections.
Sir.
All right?
Sir.
You have a great day.
Thank you so much, Your Honor. Good day, Judge.
Good afternoon, sir. Can you tell me your name?
Demarius James Taylor.
Mr. Taylor, you're here in case 2021 MM332AW on a failure to appear warrant. Judge signing that warrant set your bond amount of $1,000 on each one of your counts. I was asked the state to have an offer to resolve your case in this matter.
Yes, Your Honor, it's an adjudication of guilt for both counts. With regard to count two, with both counts, it's also credit time served. With regard to count two, it is no return to 14990 West Colonial Drive.
All right. And Ms. George, your office, I believe, represents Mr. Taylor.
Yes, Your Honor. He would like to enter a plea of no contest and accept the state's offer here today.
Can you raise your right hand and be sworn in, sir? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
All right, you put your hand down. Sir, you're here in case 2021 MM332AW on a failure to, on charges of, in count one, resisting officer without violence, and count two, trespass on property other than a structure or conveyance. Both of those counts are first-degree misdemeanors. Both of those are punishable up to 1 year in the county jail and a $1,000 fine each. Do you understand that?
Yes, sir.
Ms. George, what plea you want to enter on behalf of your client?
No contest, Your Honor.
Mr. Taylor, do you understand if I accept your plea of no contest in this matter, you're going to waive all the rights outlined on that plea form that you just signed?
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
Do you understand by entering this plea if you're not a United States citizen, it could subject you to deportation?
Yes, sir.
Did the party stipulate to a factual basis in this matter?
Yes, Your Honor.
Yes, Your Honor.
Plea.
Based on that stipulation, the court is going to find a factual basis for the entering of your plea. I'm going to accept your plea of no contest. Find your plea is freely and voluntarily entered. I'm going to adjudicate you guilty on counts 1 and 2. And I'm going to give you credit for
5 days.
the 5 days that you spent in Orange County Jail, counts 1 and 2, running concurrent to each other. The court costs and cost of prosecution in this case are $273. There's a $50 public defender application fee and $50 public defender lien. All those costs be payable directly to the clerk within 2 years of today's date. You have 30 days from today's date to appeal your judgment and sentence in writing. Do you understand that?
Yes, sir.
You have a great day, sir.
Yes, sir. Hey, thank you, sir.
All right. Good afternoon, sir. Can you tell me your name?
Giovanni Cuff.
Mr. Cuff, you're here in case 2021 MO 857AO on charges of disorderly conduct. They reviewed the charging affidavit in your case. They find probable cause for your arrest. The city of Orlando is offering a withhold of adjudication and guilt and court costs to resolve your case today. Do you want me to do that?
Yes, sir.
Can you raise your right hand to be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Or you put your hand down. Sir, the charge you're facing is a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. Do you understand that? Do you want to enter a plea of guilty or no contest to resolve that case, this charge of disorderly conduct today?
No contest.
No contest.
Do you understand by entering a plea of no contest, you're going to waive all the rights outlined on the plea form that's in front of you? Are you under the influence of any drugs, alcohol, or medication? Have you now or in the past been diagnosed with a mental health illness? Has anybody forced, threatened, or coerced you to enter this plea? You understand by entering this plea if you're not a United States citizen, it could subject you to deportation.
Yes.
I did have opportunity to review a charging affidavit in this case. I did find a factual basis contained therein. I'm going to accept your plea of no contest, find your plea is freely and voluntarily entered. I'm going to withhold adjudication of guilt. I'll give you credit for the 2 days that you spent in the Orange County Jail with 2 days credit time served. Court costs in this case are $223. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir.
You too.
1 year. All right. Okay, I'm sorry. Good afternoon, sir. Can you tell me your name?
Johnny Jerome Jenkins Jr.
Mr. Jenkins, you're here in case 2007 CT 145350 on a charge of failure to appear. Judge signed your warrant. In that case, set your bond amount of $2,000. While that's the state of Florida, they had an offer to resolve your no valid driver's license case.
Indication of guilt and credit time served, Your Honor.
All right. And does the public defender's office represent Mr. Jenkins? All right. Mr. Jenkins, you want to accept the offer from the state of Florida of an adjudication of guilt, credit time served to resolve this case today?
Yes, sir.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You put your hand down. Sir, you're here in case 2007 CT 14535 on a charge of no valid driver's license. That is a second-degree misdemeanor. It's punishable to 60 days in the county jail and a $500 fine. Do you understand that?
Yes, sir.
Do you want to enter a plea of guilty or no contest to resolve this case today?
No contest.
Do you understand by entering a plea of no contest, you don't waive all the rights outlined on the plea form that's in front of you?
Yes, sir.
Are you under the influence of any drugs, alcohol, medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
Yes.
What is that mental health illness?
I'm bipolar and schizophrenic.
All right. Are you suffering from any of the symptoms of your bipolar or schizophrenia right now?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes, sir.
I did the parties, I think I did review this one. I did review your citation in this case, as well as your driving record, did find a factual basis contained therein. I accept your plea of no contest, finds your plea is freely and voluntarily entered. I want to adjudicate you guilty of the charge. We'll give you credit for the
3 days.
3 days that you spent in Orange County Jail with 3 days credit time served. The court costs and costs of prosecution in this case are $306. I'll give you 2 years from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment sentence in writing. You have a great day, sir.
Can I say something, sir?
Sure.
Since then, I have got my driving license, but they suspended for court causes.
Yeah, so probably confer this case. So if there is a D6, the court will lift it. All right, have a great day, sir.
You too, sir.
Good afternoon, sir. Can you tell me your name?
Terrell Johnson.
Mr. Johnson, you're here in case 2020 MM 9043 AO on charge of resisting officer without, we'll take it back. You're here this afternoon, actually, in 2020 CT 337 AO, AE on charges of failure to appear. Judge signing your warrant. In that case, set your bond in the amount of $1,000. The state, do you have an offer to resolve all his cases or just You also have a resisting without violence case in 2020 MM 9043 AO. I was asking this.
Yes, Your Honor, it's an adjudication of guilt, credit time served. With regard to 20 MM 9043, there's also a cost of investigation of $231.90 to the Eatonville Police Department.
Oh, okay.
Ms. George, does your office represent Mr. Johnson in these cases?
Yes, Your Honor. And I did have a chance to speak with him. He would like to accept the state's offer here today, Your Honor, and enter a plea of no contest.
All right, sir, can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
You put your hand down. Sir, you're here in case 2020 MM 9043 AO on charge of resisting officer without violence. That is a first-degree misdemeanor. It's punishable to 1 year in the county jail and a $1,000 fine. You're also here in case 2020 CT 337 AE on a charge of driver license suspended. That is a second-degree misdemeanor, punishable to 60 days in the county jail and a $500 fine. Do you understand that? Ms. George, what plea you want to enter on behalf of your client as to both of these cases?
No contest, Your Honor.
Mr. Johnson, you understand if the court accepts your plea of no contest, you're waiving all your rights in those two cases that are outlined on the plea form. All right, so in each case, you have a right to you have a right to have a trial. You have the right to challenge the evidence against you, call witnesses on your behalf, have the public defender's office represent you at that trial, waiving your right to appeal, waiving your right to remain silent, all those things in each one of those cases. All right, you understand that?
Sir.
Are you under the influence of any drugs, alcohol, and medication? Have you now or in the past been diagnosed with a mental health illness?
Sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand about entering this plea if you're not a United States citizen, it could subject you to deportation. I can't hear you.
Yes, sir.
All right. Did the parties stipulate to a factual basis as to these two cases?
Yes, Your Honor.
Yes, Your Honor.
Based on the stipulation, the court will find a factual basis in each one of your cases. When accept your plea of no contest in each case, find your plea is freely and voluntarily entered. I'm going to start my sentencing with case 2020 MM9043AO. The court is going to adjudicate you guilty of the charge, give you credit for the
4 days.
4 days that you spent in the Orange County Jail with 4 days credit time served. Court costs and costs of prosecution in that case are $273. There's a $50 public defender application fee and $50 public defender lien. There's also cost of investigation to the Edenville Police Department in the amount of $231.90.
They got that money in my.
I will combine all your costs for payment at the end. All right, sir, you also, in 2020 CT 337 AE, I want to adjudicate you guilty of that charge, give you credit for the
3 days.
3 days that you spent in the Orange County Jail with 3 days credit time served. Court costs in that case are $306. I'm not going to impose the lien and PDAP since we already did it on the other case. I want to combine both these cases for costs. I'm going to give you 3 years from today's date to pay that money in both cases directly to the clerk in full. You're going to have 30 days from today's date to appeal your judgment and sentence in writing in each case. You understand?
Sir.
All right. You have a great day, sir.
Thank you.
Good afternoon, sir. Can you tell me your name?
Bastian Acosta.
Mr. Acosta, you're here in case 2021 CF 8903AO on charges of possession of cocaine with a weapon, possession of oxycodone, possession of cannabis, possession of a firearm, and the commission of a felony. You review your charging affidavit in your case did find probable cause for your arrest. You're going to stay your bond in count one, amount of $7,500. Count two, we're going to reduce it to $150. Count three, $150, and count four, $150. You also be subject to pretrial release in this case. Conditions that you not possess or consume any drugs or alcohol without a valid prescription. You be subject to the drug and alcohol testing at your expense. Not allowed to possess any weapons or firearms. Weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this matter. You have a great day, sir.
Thank you.
Good afternoon, sir. Can you tell me your name?
Cornelius Brothers.
Sir, you're here in case 2021 CF 4534AO on a failure to appear warrant. Judge in that case set your bond at no bond. You're also here in 2021 MM 5211AO for charge of trespass after warning. They reviewed the charging affidavit in that case, did find probable cause for your arrest. I don't know if you're interested in resolving that case.
Yeah.
All right. So there was an offer that you wanted to convey.
It was not conveyed, but it would be an adjudication of guilt and credit time served, Your Honor.
All right. Do you want to accept that offer from the state of Florida of adjudication of guilt, credit time, sir?
Yeah.
All right. Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
All right, sir. You're here in case 2021 MM 5211AO on charge of trespass after warning. That's a first-degree misdemeanor. It's punishable up to 1 year in the county jail and a $1,000 fine. You understand that? Do you want to enter a plea of guilty or no contest to resolve this case with the state?
No contest.
You understand by entering a plea of no contest, you're going to be waiving your right to have a trial in this matter?
Yeah.
Waiving your right to have an attorney represent you at that trial. Do you understand that?
Yeah.
You're also waiving your right, you know what I'm saying? You're also waiving your right to challenge the state's evidence, question the state's witnesses, and call witnesses on your behalf. Do you understand that?
Yeah.
You're waiving your right, you know what I'm saying? You're waiving your right to remain silent.
Yeah.
You understand? You're waiving your right to appeal any errors in this case, except the court's jurisdiction over you in the sentence I'm going to impose. You understand that?
Yeah.
So you're waiving your right to appeal. Only thing you can appeal is whether I had the power to sentence you and whether the sentence I gave was legal. You understand that? So I can't sentence you for 2 years on a case where you only can get 1 year, which we're not doing anyways, but
So you're talking about,
all right, you gotta cover your face. You gotta put your mask above your nose, please.
you're talking about that case,
Your trespass case.
okay, trespassing.
Yeah, the trespass case. So you're waiving your right to appeal any other matters. You understand that?
Yeah, yeah.
All right. Are you under the influence of any drugs, alcohol, or medication?
No.
Have you now in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or coerced you to enter this plea?
No.
Do you understand why entering this plea, if you're not a United States citizen, it could subject you to deportation?
Yeah.
I did review your charging affidavit, so I did find a factual basis contained therein. I'll accept your plea of no contest, find your plea is freely and voluntarily entered. I want to adjudicate you guilty of the charge and give you credit for the 2 days that you spent in the Orange County Jail with 2 days credit time served. Court costs and costs of prosecution in this case are $273. I'll give you 2 years from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing in this case. You have a great day, sir.
Your Honor, did we address the case that he's here for, the FTA, the petty theft?
Yep, no bond.
Okay.
I did that first, and then we talked about the trespass. Nope, I don't think so. Oh. No, that's the petty theft case. No, this case he had an FTA on.
Oh, okay.
Let me make sure. Nope, it's a different case. No, four. It's on the same case, yeah. What it says out on ROR. I had a FAD that said he was out on ROR on the case that he had no bond from a warrant.
For Brodus?
Yep. All right, thanks, sir. Good afternoon, sir. Can you tell me your name?
My name is Lionel Kennedy Sr.
Sir, you're here in case 2020 CF 2586 AO on a failure of sex offender to register. Judge signing your warrant in this case has already found probable cause for your arrest. We're going to set your bond in this case amount of $2,500. Condition of your bond is that you have 48 hours for once you leave the Orange County Jail to report to the Orange County Sheriff's Office as a violent sexual predator or sexual offender. Want to appoint the public defender to represent you in this matter. You have a great day, sir.
All right.
Counsel, do you have a case with me?
It's set at 1 o'clock, Judge. Initial appearance on Chester Gardner. It's a brand-new case. I just got my notice of appearance filed on the portal. Mark Fender on behalf of Chester Gardner, whenever you're ready.
We can call him up after. He's a felon. 2,500. Good afternoon, sir. Can you tell me your name?
Andrew Chico.
Mr. Chico, you're here in case 2021 CF 8879 AO on charges of burglary of an unoccupied dwelling and criminal mischief. They reviewed the charging affidavit in your case. They find probable cause for your arrest. Let's say your bond in count 1 amount of $5,000, count 2 $100. Condition of the bond that you're not allowed to return to the scene of the location. Have no contact with any victims, witnesses, or co-defendants in this case. You may not possess any weapons or firearms. The weapons and firearms you have need to be returned to law enforcement within 24 hours of your release. I'm also going to appoint the public defender to represent you in this matter. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
Chester Marachan Gardner.
And Mark Bender on behalf of Mr. Gardner, Judge. Nice to meet you.
All right.
I filed my notice of appearance just a few hours ago because the case just showed up because it wasn't an arrest warrant.
Correct. All right, Mr. Gardner, you're here in case 2021 CF 8353AO on charges of attempted aggravated assault on a law enforcement officer and fleeing attempt to elude law enforcement. Judge signing your warrant in this case has already found probable cause for your arrest. Counsel, you gotta cover your nose. All right, Counsel, you want to tell me anything about
Judge, we
Mr. Gardner?
we'd enter a not guilty plea at this time. I would.
Well, we're his initial appearance, so he hasn't been charged officially yet. We're just set release conditions at this point.
Yes, Judge, for some reason, the fleeing and attempting to elude is a third-degree felony, but it was set at no bond. I would ask that the court set a reasonable bond. He does have a $10,000 bond on the other count. I think it's a third-degree felony. There's no reason for no bond. And I didn't see any signature where, I think it's Judge Strobridge that prohibited you from changing the bond at IA.
No, this is a brand-new case, so I can modify conditions as I see fit, because I'm in a better position than the warrant signing judge to ascertain what risks.
Does the state have any objection to setting a bond?
No, he's going to get a bond. He's entitled to one. I'm just trying to figure out why my counterpart, Judge Gibson, set his bond at $10,000 on count one and then set his bond at no bond at count two. So usually she has a reason for what she does.
Yeah, I read the report. This was basically he was parked and he drove off. I mean, I know the officer was irritated, but I think he's entitled to a bond.
No, he's entitled to a bond. All right. Sir, it's a count two. So count one will set your bond amount $10,000. Count two, we're going to set your bond in an amount of $2,500. Condition your bond that you're not operating a motor vehicle without a valid driver's license. And you already have counsel representing you. So have a great day, sir.
Thank you very much, Judge.
Thank you, Your Honor.
You'll get out today. I'll call her, okay?
Thank you.
1,000 count one, 2,500 count two. All right. Good afternoon, sir. Can you tell me your name?
Monty Christie.
Mr. Christie, you're here in case 2021 CF 8901 AO on a charge of armed trafficking and 28 grams or more of methamphetamine, trafficking in oxycodone of 4 grams or more, possession of a weapon by a convicted felon, possession of ammunition by a convicted felon, possession of cannabis. You're also here in case 2021 CT 5339 AO on charge of no valid driver's license. Say, what are you asking me to do as to count one of 2021 CF 8901 AO?
Your Honor, as that is punishable by life, I would ask that the defendant be held no bond.
All right. Ms. George?
Argument reserved the right to have an argument, Your Honor.
All right, going to appoint a public defender to represent you. As a count one, the armed trafficking charge going to hold you at no bond. Count two, going to stay your bond amount of $200,000. Count three, we're going to set your bond amount of $150. Count four, $150. Count five, $100. Condition of your bond is that you not possess any drugs, alcohol without a valid prescription. You not associate yourself with any known drug dealers or drug users. You may not possess any weapons or firearms. The weapons and firearms you have need to be turned over to law enforcement within 24 hours of your release. You're also, whoever is to post your bond in this case is going to comply with Florida Statute 903.046, sub 2, sub F. File an affidavit with the court attesting that the funds used to bond you out did not come from any illegal or illicit source. In 2021 CT 5339 AO, we're going to set your bond amount of $500. The condition that you're not operating a motor vehicle without a valid driver's license. All right, going to appoint a public defender to represent you in both cases. You have a great day, sir. Good afternoon, sir. Can you tell me your name? Sir, you're here in case 2020 CF 3654, as well as 2020 CF 6132 AO, both for failure to appear. Judge, in both cases, set your bond amount of $7,500 on each one of your cases. The bond's going to remain as set. You also have in case you're out on bond on 2020 MM 4731 AO. Going to not take any action as to that case. Have a great day, sir. Good afternoon, sir. Can you tell me your name? Cover your face. There you go.
Pardon, Corinthian?
Sir, you're here in case 2021 CF 8900 AO on a driver license suspended as a third or subsequent offender. The reviewed charging affidavit in this case did find probable cause for your arrest. Let's say your bond is about, in this case, about $2,500. Condition your bond that you not operate a motor vehicle without a valid driver's license. Want to appoint the public defender to represent you in this matter. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
Scott Trail, Denmark.
Mr. Denmark, you're here in case 2021 CF 8896 AO on charge of armed burglary, grand theft from a dwelling, more than $100, possession of a weapon by a convicted felon, criminal mischief, possession of a weapon by a convicted felon, and possession of MDMA or ecstasy. They reviewed a charging affidavit, did find probable cause for your arrest as to those charges. State, what do you ask me to do as to count one of the charging affidavit?
Your Honor, as armed burglary is punishable by life, I would ask that defendant be held no bond.
And Ms. George, I want to appoint a public defender to represent you, sir.
No argument reserved, right to have the Arthur hearing.
All right, Mr. Denmark, is the count one, the court's going to hold you at no bond. Count two, going to stay your bond amount of $1,000. Count three, $5,000. And count four, going to set your bond amount of $100. Condition of your bond is that you're not allowed to return to the scene of the location, may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release, and you have no contact with your victims, witnesses, or witnesses in this case. You also not possess any drugs or alcohol without a valid prescription. You are out on bond in case 2021 CF 286 AO. In that case, the court is going to revoke that bond, set a new bond in the amount of $0 as to that matter. Want to appoint the public defender to represent you in all cases you're not already appointed.
Did you go to court on this?
Yeah, I'll say, Your Honor, he has another case.
Oh, okay.
I did the out on bond.
No, 8895.
Oh, sorry. There it is. I think I did. No, sorry.
Either you were ROR'd, you were out for this case.
88. Oh, sorry. I was right. Sorry. And 2021 CF 8895. They review that charging affidavit. Going to stay your bond in count one, $5,000. Count two, $1,000. Condition that bond, no drugs, no alcohol, no weapons, no firearms. The weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. All right, have a great day, sir.
Your Honor, can we pass by Mr. Frank?
Mm-hmm.
Grant bonded. On him. There you go.
Good afternoon, sir. Can you tell me your name? So you're Mr. Ham? All right. Mr. Ham, you're here in case 2020 CF 8859, as well as 2020 CF 5832 AO. For both of those cases for failure to appear, the judge in those cases set your bond amount of $0 as to both cases. Your bond's going to remain as set. I believe you already had the public defender representing you in those cases, correct? Regional Conflict Counsel? Or you have an attorney in both cases?
Don't. Oh.
All right, so you can get in front of that judge, explain where you were if you did not intentionally fail to appear. All right, you have a great day.
We have Mr. Freak here, Your Honor.
Good afternoon, sir. Can you tell me your name?
Terry is Demetrius Frank, Senior.
Mr. Frank, you're here in case 2021 CF 8859 AO on a charge of interference with custody of a minor. The judge signing your warrant, in this case, sets your bond in the amount of $2,000, found probable cause and sets your bond amount $2,500. One question. Does he have any active injunctions, Ms. Davis? I know, yeah, I see we have the child support, but
I'm not too sure, Your Honor. I can search and see.
yeah, because I was gonna release him on pretrial release. But I was trying to make sure that he didn't have any active injunctions with this, especially this particular mother of the child.
I don't get in trouble, Your Honor.
No, I hope so. I hope. It's been a while since, we seen you for something major.
Yes, sir. I grew up.
Well, some point.
Yes, sir. I'm a father now. Yes, sir.
No, he doesn't.
All right, Mr. Frank, we're gonna release you on pretrial release in this case. But you are gonna, say again?
Bond and PTR?
No, just straight PTR. It's just, I don't think this charge is a domestic violence.
Oh, because you
Case.
said $2,500.
No, the judge set a bond on his warrant for my $2,500, but I was gonna release him straight PTR. All right, but, we gotta deal with paying child support. Make sure you get caught up on that.
Yes, sir.
I'm not the judge for that.
Yes, sir.
I'm just to keep you out of trouble, keep you in good graces with the mom of that child.
Yes, sir.
Just do what you gotta do. See?
Any conditions? No?
That's why I asked. I mean, if he is abide by, if you had any other injunctions with that child's mother, then I was gonna make that a condition. But straight PTR, just stay out of trouble.
Yes, sir. Have a good day. Thank you.
I was gonna appoint a public defender to represent him as well. Good afternoon, sir. Can you tell me your name?
Damon Hatchett, sir.
Mr. Hatchling, you're here in case 2020 CF 12467 on a warrant in case charges of possession of controlled substance, possession of cannabis, and tampering with physical evidence. The judge already found probable cause for your arrest in that case. You're here also in case 2020 MM 5342 AO for a failure to appear. Judge set your bond amount of $1,000 on count 2 and $500 on count 3. You're also here in case 2020 MM 4130 for a failure to appear warrant. The judge in that case set your bond amount of $1,000 on each count. You're here in case 2021 CF 8857 AO for a charge of grand theft motor vehicle. I did review the charging affidavit. In that case, did find probable cause for your arrest as to that case. I'm going to set your bond in that case in the amount of $2,000, conditional on your bond that you have no contact with your victims or witnesses from that case. Operate a motor vehicle without a valid driver's license. In 2020 CF 12467, count 1, we're going to set your bond amount of $1,000. Count 2, $150. Count 3, $150. Condition of that bond that you not possess, consuming drugs or alcohol without a valid prescription. Now associate yourself with any known drug dealers or drug users. You be subject to random drug and alcohol testing at your expense in that case. I'm going to appoint a public defender to represent you in all your cases. You have a great day, sir.
How many cases is that?
You have 4 cases. 1, 2, 3, 4. 2 misdemeanor cases and 2 felony cases.
Oh, I thought I heard. A lot.
Did I count that wrong?
No, you counted it right.
Okay, make sure.
Yeah, you have 2 misdemeanors.
They just accuse me of being blind up here or something, like Mr. Magoo. Trying to make sure I got it right.
I think he stayed them all except for.
Yep, so bonds, I think I got everybody.
On 20,
Got all the-
yeah,
got everybody.
8857, he changed it to 2,000 instead of 1,000.
Just waiting on her.
And on
Yep, gotcha.
the other CF, the subsidiaries, he changed it to 150 instead of 100.
Yeah.
Good afternoon, sir. Can you tell me your name?
Jeffrey Lee Hawk.
Mr. Hawk, you're here in case 2021 CF 8898 AO on charges of possession of cocaine. Did review the charging affidavit in your case, did find probable cause for your arrest. No?
I would, no, yeah,
I was wondering.
no.
I want to state your bond in this case amount of $1,000. Condition of your bond that you not possess or consume any drugs or alcohol without valid prescription. You not associate yourself with any known drug dealers or drug users. And be subject to random drug and alcohol testing at your expense. I'm going to appoint a public defender to represent you in this matter. You have a great afternoon, sir.
You too.
Good afternoon, sir. Can you tell me your name?
Good afternoon, sir. My name is Stephen Darnell Holland Jr.
Mr. Holland, you're here in case 2021 CF 8889 AO on charge of trafficking fentanyl 4 grams or more, possession of cocaine, possession of alprazolam, resisting officer without violence, and possession of cannabis. Reviewed the charging affidavit in your case, did find probable cause for your arrest. State your bond account 1 in the amount of $250,000. Count 2, 150, count 3, 150, count 4, 100, and count 5, 100. Condition your bond, you not possess or consume any drugs or alcohol without a valid prescription. That you also not associate yourself with any known drug dealers or drug users. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And I'm going to appoint the public defender to represent you in this matter. This probation case is out of Orange County.
One moment.
It's 2020 CF 4336 AO. Yep.
It is.
All right, sir, you are on probation in case 2020 CF 4336. The court reviewing the charging affidavit in case 2020 CF 8889 did find probable cause for on-view violation of probation. We're going to set your bond at no bond as to that on-view violation. I'm going to appoint a public defender to represent you in that matter as well. You have a great day, sir.
Drew Hunt, Bundit.
Okay. Good afternoon, sir. Can you tell me your name?
Demetrius Jackson.
Mr. Jackson, you're here in case 2019 CF 1146 AO for a failure to appear warrant. You're also here, the judge in that case set your bond at no bond. The condition of that bond is you have no contact with the victim in that case. In case 2020 MM 222 AA, you're also here for a failure to appear warrant. Judge in that case set your bond amount of $500. And in 2020 CT 378 AA, the judge in that case set your bond amount of $2,000 for a failure to appear. As to the misdemeanor cases, Ms. George, was there any offers that were already conveyed to him?
No, Your Honor, I didn't get any offers.
And say, were you making any offers as to the misdemeanor cases?
With regard to the misdemeanors, Your Honor, I would do an adjudication of guilt and credit time served.
One's a no valid and the other ones are resisting. All right, Mr. Jackson, do you want to accept those offers from the state of Florida to resolve your misdemeanor cases? I can't do anything about your felony charge.
Yes, sir.
All right. And Ms. George, does your office represent him on those misdemeanor cases?
I don't see on the track.
On the traffic case?
I didn't see it.
1 second. Yeah. Molina Randall? Did you hire a private attorney on one of your cases?
Yeah, but she had got off my case.
Was there a motion to withdraw somewhere? Yeah, she is. Yeah, she's off the case. All right, she is off the case. All right, sir, can you raise your right hand and be sworn in?
Sir.
Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Sir.
All right, you put your hand down. Sir, in case 2020 MM 222AA, you're here for a charge of resisting officer without violence. That's a first-degree misdemeanor. It's punishable up to 1 year in the county jail and a $1,000 fine. Do you understand that?
Yes, sir.
You're also here in case 2020 CT 378AA on a charge of no valid driver's license. That is a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. Do you understand that?
Yes, sir.
Do you want to enter pleas of guilty or no contest to resolve both these cases this afternoon?
No contest.
No contest.
All right. You understand by entering a plea of no contest, you're going to be waiving your right to have a trial in this matter.
Yes, sir.
In each one of your cases, you have the right to have a trial. Do you understand that?
Yes, sir.
You understand each case? Sir, sorry?
As I'm getting as I'm signing the plea right now?
Yes, sir.
Okay.
You understand that you're waiving your right to have an attorney represent you in each one of your cases if you can't afford it?
Yes, sir.
You understand you're waiving your right to have, to be able to challenge the state's evidence and question the state's witnesses and call witnesses on your behalf. Do you understand that?
Yes, sir.
You understand that you are waiving your right to appeal any errors in this case except the court's jurisdiction over you and the sentence I'm going to impose.
Yes, sir.
You understand you are waiving your right to remain silent
Yes, sir.
as to these two charges.
Yes, sir.
All right. Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes, sir.
Say, can you give me a little facts on both cases? Because I have an opportunity to look at these two. 19 CF cases, you have
It's the same thing.
I want to make sure you have it.
That I'm not sure, it just came as a.
Oh, give me a break. I apologize, Your Honor. I'm finding it hard to find the information.
Can you pull me up these two?
But even if you are on the law, the failure to appear, it's not gonna change anything. So if you're on the law, those are going to your attorneys, you fail to show up to court, that's why
You need me to print it, Ms. Darlene?
And who do you have a private attorney for that?
No, I don't have, this is, I want a lawyer. I think it's a pure one. I'm asking you.
I can talk to him.
You can talk to when I. Once he finishes. You'll be. Only on the.
I'm looking for a factual basis.
Yeah.
There we go. Ms. Davis is on it today. I did see the misdemeanor one.
Ms. Davis, were you able to provide both
I did both.
think they were from the same day.
Thank you so much.
Yep. All right. All right, they reviewed the charging affidavits in both your cases. They find a factual basis contained therein. When I accept your plea of no contest in this matter, going to find your plea is freely and voluntarily entered. I'm going to start my sentencing in case 2020 MM 222 AA. I'm going to adjudicate you guilty of the charge. Give you credit for the
4 days. and
4 days that you spent in Orange County Jail with 4 days credit time served. Court costs and costs of prosecution in that case are $273. You're also in 2020 CT 378 AA. One to adjudicate you guilty of that charge. Did find find a factual basis of accepting your plea of no contest. Find it's freely and voluntarily entered. Going to give you credit for the 4 days you spent in Orange County Jail with 4 days credit time served you have on that case. The court costs in that case are $306. Combine both these cases for payment. We'll give you 2 years from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing in each case.
Your Honor, he would like,
Say again?
he would like to say something to you.
But,
already
I mean, don't talk about your other case,
Mhm.
but go ahead.
With other case, 2019,
Yeah,
I can't talk about that one.
no, because you got an attorney on that case. Looks like you're getting ready for a trial.
No, I don't have an attorney. He withdraw from my case.
You want a public defender to represent you in that case?
Yes, ma'am.
All right,
Me,
now
yes, sir.
appoint a public defender to represent you in the 2019 CF 1146 AO case, all right? So make sure you have a representation in that case.
So I can talk about it?
I advised him not to talk about the facts.
Well, I'm gonna tell you this, there's a prosecutor sitting to my right. They can use everything you say against you, like from your court, in your trial, so.
I understand. I was trying to find out was I on R&R on that case. Because I've been on bond for 2 years on that case. I really don't remember anything. I had got my court date. Yeah.
Yeah.
I had gotten confused.
All right, so you talk to the judge assigned to your case, and you file, that's the public defender's office file a bond motion on your behalf. Maybe you can get, if that judge feels comfortable letting you out, then you will
say
be
what?
out.
Your Honor, I can't. You said a bond motion?
Yes, sir.
Uh,
So the law doesn't give me authorization to change your failure to appear capias unless the judge that signed that capias previously told him, like send me an email saying, Judge Bain, you have authorization to change my bonds on these cases, which I don't have in this situation. So the only way you can get that bond changed is go see the judge that signed the warrant, which will be in your division when you file a bond motion, all right?
So I got to go back downtown?
Yes, sir.
How long would it take to file the bond motion?
You gotta call a number or get in contact with the PDs in your division, get you in front of that judge. They have to see you within, I think,
This number?
in 3 days, once they ask for a hearing, so.
3 days?
Once they ask for the hearing. So you gotta make sure they ask for the hearing. You can't just say 3 days, oh, don't have a bond motion automatically filed. That's not gonna happen.
Yeah.
But if they file a bond motion, some judge should be able to see you within like 3 days of that time.
Can I release on like anchor money or something?
We don't have that in the state, here in Orange County anymore. Somebody messed that up for everybody.
All right, thank you.
All right, have a great day.
All right.
They did. They messed it up. We're doing fine. Good afternoon, sir. Can you tell me your name?
My name is Jamarli Elijah John.
Mr. John, you're here in case 2021 CF 6805 AO on a charge of robbery with a firearm. Judge signing your warrant in this case has already found probable cause for your arrest. State we asking that I do as to his bond amounts.
Your Honor, robbery with the firearm is punishable by life. I would ask the defendant be held no bond.
All right, Ms. George, I want to appoint a public defender to represent you in this case.
No argument, reserve the right to argue hanging the charge.
All right, Mr. John, in this case, going to hold you at no bond. Condition of your bonds, you're not allowed to have any contact with any victims or witnesses or co-defendants from this case. You may not possess any weapons or firearms. Any weapons or firearms you have need to return to law enforcement within 24 hours of your release, and you're not allowed to return to the scene of the location of this incident. Now, you looks like, is he still on juvenile probation?
He has a hold for them, so I believe so, Your Honor.
Yes, sir.
All right. So, Mr. John, I don't know if somebody discussed this with you while you were in juvenile, and try to clear your mind as to what's about to happen to you in life.
No,
You're 18 years old. Just listen to me. You're 18 years old. This charge you're facing, you go to prison for the rest of your entire life. So the next 70 years, probably plus, of your life, you be sitting in some little cell somewhere. They're going, like, when you die, they're gonna put you in a little pine box and put you in a fire and then put you in a little box and send it over to your mom if she's still alive. You understand that? So you may want to raise your expectations about what you have for your life and raise the value that you placed on your life, because the state of Florida knows exactly how much it's gonna cost to house you for the rest of your life and take care of you. All right? So how about just thoughts? Just something to think about while you're sitting over there. You may want to take advantage of some of the programs we have here at the Orange County Jail while you're sitting there. I don't know if you got your GED taken care of and all those things like that. I don't know if you graduated from high school, but you may want to get that done. Get some job training, get something to do other than spend the rest of your life in prison. All right?
That's why I turned myself in, sir. I was trying to see my daughter and everything.
All right. Well, that's even more important. You got somebody actually depending on you.
Yes, sir.
It's looking up to you.
Yes, sir.
And so if you go like this, her expectations of life are going to go like that too.
Over, sir.
All right. Have a great day. Good afternoon, sir. Can you tell me your name?
Moset La Fortune.
Sir, you're here in case 2021 CF 888 AO on the charges of unauthorized possession of identification card and possession of and grand theft motor vehicle. Did review the charging affidavit in your case. Did find probable cause for your arrest. Going to stay your bond in this matter, amount of $2,500 on count 1 and $150 on count 2. Condition of the bonds, you're not allowed to have any contact with any victims or witnesses from this case. You may not possess any other person's identification except your own. I'm going to appoint the public defender to represent you in this matter. You have a great day, sir.
Thank you, sir.
Good afternoon, sir. Can you tell me your name?
James Lamb.
Mr. Lamb, you're here in case 2021 CF 3814 AO on a failure to appear warrant. The judge in this case set your bond at no bond. Your bonds can remain as set in that amount. You already had the public defender representing you in your case?
No, sir.
All right, I'm going to appoint a public defender to represent you in this matter. You have a great day, sir. It's after 1, so we do Ms. Torres whenever you guys are ready. Good afternoon, sir. Can you tell me your name? Yep, there, covered up. There you go. Tell me your name.
Keith Letzum.
Mr. Letzum, you're here in a few matters. The first one being 2021 CT 1350AW on a charge of driver on license suspended. You're also here in case 2021 CF 8906 AO on a fleeing to attempt to elude law enforcement with license sirens activated. You're also here in case 2021 CF 8907 AO on charges of possession of cannabis and resisting officer without violence. Did review the charging affidavits in your cases. Did find probable cause for your arrest. That's your driver license suspended case in 21 CT 13050 AW. I'm going to stay your bond amount of $500. Condition your bond is you not operate a motor vehicle without a valid driver's license. In 2021 CF 8906 AO, we're going to set your bond amount of $3,500. Condition of that bond is you also not operate a motor vehicle without a valid driver's license. In case 2021 CF 8907 AO, we'll set your bond amount of $150 in count 1 and $100 in count 2. Condition of that bond, you not possess or consume any drugs or alcohol without a valid prescription. You'll be subject to random drug and alcohol testing at your expense in that case. We're going to appoint the public defender to represent you in all of your cases. You have a great day, sir.
Good afternoon, Your Honor. This is Laura Arroyo, State Certified Interpreter, already previously sworn today.
Good afternoon, Mr. Royal. This is Judge Bain calling from the BRC. Can you see if you can make a connection with my podium?
Yes, absolutely. 1 second.
Sí.
Connection is established.
All right. Good afternoon, ma'am. Can you tell me your name?
María Torres.
Maria Torres.
Ms. Torres, you're here in case 2019 CF 1460 AO for a failure to appear warrant. The judge signing your warrant in this case set your bond amount of $2,000 on your first count and $200 on your second count. Your bonds are going to remain as set in this case. I'm going to appoint you the public defender if you're not already appointed them in this matter. You have a great day, ma'am. All right, Ms. Rudd, that was my only case. You have a great day.
Oh, you likewise. Thank you. Bye-bye.
Good afternoon, sir. Can you tell me your name?
Joshua Martinez.
Mr. Martinez, you are here in case 2021 CF 8815 on charge of sexual battery. The judge signing your warrant in this case has already found probable cause for your arrest. Going to set your bond in this matter, an amount of $500,000. Condition of your bond is that you to have no contact with any victims or witnesses in this matter. You may not possess any weapons or firearms. The weapons or firearms you have need to be returned with law enforcement within 24 hours of your release, and no contact with any co-defendants. We're going to appoint the public defender to represent you in this matter. You have a great day, sir.
Thank you so much.
Here, take it. My name is Miller Heff, Your Honor.
What do you miss? Huh? For Martinez? I mean, for, All right. I'm sorry. You said who bonded? Molia bonded?
Yes.
All right.
It's mental health.
The mental health, okay, I'm sorry, Josh. All right, this is case 2021 MM 5206AO as well as 2021 CF 8860. I'm going to appoint a public defender to represent Mr. Amoli.
I'll waive the appearance, Your Honor.
All right. I did review the charging affidavit in 2021 MM 5206AO due to find probable cause. Going to state his bond amount of $500 in that case. In 2021 CF 8860AO state, what are you asking me to do as to count one with the charges of burglary of a structure with assault of battery or in?
Your Honor, as that is punishable by life, I would ask the defendant be held no bond.
And Ms. George, what are you asking that the court do as to that charge?
No argument. We reserve the right to have argument.
All right, the judge signed his warrant. In that case, has already found probable cause as to that matter. I'm going to state his bond at no bond in count one. Count two, going to state his bond amount of $150. Count three, $150, and count four, $100. Condition of the bond, no contact between victims or witnesses in that case. No return to the scene of the location. May not possess any weapons or firearms. Any weapons or firearms he has need to be returned to law enforcement within 24 hours of his release. Good afternoon, sir. Can you tell me your name?
Edwin Mortis Fernandez.
Sir, you're here in case 2021 CF 8612AO on charge of first-degree murder with a firearm. The judge signing your warrant in this case has already found probable cause for your arrest. State, what are you asking me to do as to Mr. Is it Morgarinas? Say your last name again?
Mortis.
Morges, Mr. Morges.
Your Honor, that is punishable by life. I would ask defendant be held no bond.
All right, actually, this is a capital offense punishable by death.
No argument. We reserve the right to have an Arthur hearing, Your Honor.
All right, sir, I'm going to hold you at no bond as to this matter, condition that you have no contact with any victims, witnesses, or co-defendants, or victims' families, witnesses, or co-defendants in this matter, that you not return to the scene of the location where this incident happened, you may not possess any weapons or firearms. The weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I'm going to appoint a public defender to represent you in this matter. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
Jonathan Morris.
Mr. Morris, you're here in case 2021 CF 8891AO on charge of uttering a forgery, possession of cocaine, false information to law enforcement during the investigation, forgery of a check, fraudulent use of personal identification of another, and possession of drug paraphernalia. They reviewed the charging affidavit in your case, did find probable cause for your arrest. Going to stay your bond amount of $1,000 as count one, $1,000 count two, $100 as a count three, count 4, 1,000, count 5, 1,000, count 6, 100. Condition of your bond that you not possess or consume any drugs or alcohol without a valid prescription. And you also not possess any identification of anyone else except your own. You're also subject to random drug and alcohol testing at your expense. I'm going to appoint the public defender to represent you in this matter. You have a great day, sir.
Step out that way. Christian Ramos, he refused court.
This is case 2021 CF 8852AO. Mr. Ramos is going to appoint a public defender to represent him in this matter.
I'll waive the appearance, Your Honor.
I did review the charging affidavit in his case. Going to define probable cause, going to set his bond in count 1, amount of $1,000. Count 2, going to stay at $15,000. And count 3, going to set it at $100, condition of his bond. Not allowed to possess any drugs or alcohol without a valid prescription. Be subject to random drug testing at his expense.
Sean Roberts, he refused court.
All right, this is case 2021 CF 8890AO. Mr. Roberts is here on charge of sexual battery on a child between the age of 12 and 17 years old.
I'll waive the appearance, Your Honor.
Oh, sorry, I'm appointed public defender to represent Ms. Roberts. So there you go. Now you go, Ms. George.
I'll waive the appearance, Your Honor.
All right, and state, what are you asking? I do ask this charge.
Your Honor, that is punishable by life. I would ask defendant be held no bond.
The court did review the charging affidavit in this case, did find probable cause for his arrest. Going will state his bond at no bond in this case. Condition of the bond, he had no contact with any victims or witnesses from this case. He may not return to the scene of the location where this incident happened. He may not possess any weapons or firearms. The weapons or firearms he has need to be returned to law enforcement within 24 hours of his release. He may not have any unsupervised contact with any child under the age of 18 years old. Good afternoon, sir. Can you tell me your name?
Dwight Sandifer.
Sir, you're here in case 2021 CF 8834 on charge of failures of sex offender to register on 2 counts. Judge signed your warrant in this case, set your bond at, already found probable cause for your arrest. Gonna set your bond in each one of your counts amount of $1,500. Condition of your bond that you have 48 hours from the time you are released from the Orange County Jail to register at the sheriff's office as a violent sexual predator or sexual offender in this case. Want to appoint the public defender to represent you in this matter? You have a great day, sir.
Because they made a mistake on the paperwork over there. It said the 28.
Sir, if you have a defense, that's great, but you need to talk to your attorney about that defense. I'm not the judge for your trial, so if you want a trial or there's a defense that you want to bring to the state's attention, that's what your attorney's for, okay? You have a great day, sir. Good afternoon, ma'am. Can you tell me your name?
Haley Sherwood.
Ms. Sherwood, you're here in case 2021 CF 14AO on a violation of conditional release. Judge signed your warrant in that case, set your bond in amount of $1,500.
Been in the
Hold
hospital.
on, wait.
Sorry.
Did Miss Judge Barber didn't specify on what counts, so is it going to do 1,000 on count 1, 500 on count 2? Because she has 2 counts, correct? 4 counts?
I guess they just did it as one count.
So is it 4 counts? All right, let's do 500 on each. Hold on, nope, I can't count. I'm going wrong.
It's okay.
Let's do 500, 500, 250, and 250. Because I don't want her to be stuck here because like, oh, she doesn't have a bond assigned to these other counts. So let's do 500, 500, 250, and 250. That way has the correct amount.
Your Honor, how many counts do you see?
Madam Clerk says she has four. So I'm trying to spread the two, one, like,
Dropped, for sure.
I don't know, what'd you guys file?
I see a possession of meth, possession of drug paraphernalia, and petty theft, $100 or more.
And, sorry, it's 3 counts you guys filed?
I see 3.
All right, so that makes it easy. So 500, 500 ROR.
Is it not 1,500?
There you go. Sounds like we did it.
So 500 3 times and then RR?
Right.
Okay, so 500 3 times and then ROR.
What's ROR mean?
We're gonna release you on your own recognizance as to that charge. Yeah, so your cannabis charge, I guess, we're releasing you on your own recognizance, not gonna give you, you don't have an assigned bond as to that count. The other 3 counts, 500, 500.
I don't pay the bond.
Say again? I can't hear you.
What happens if I don't pay bond?
You'll see Judge Barber at your next court date.
Okay.
If you want to if you can't afford bond, you got to call the number on the sheet of paper, get in contact with your attorney down at the public defender's office, and get you in front of Judge Barber sooner than that. All right? Have a great day.
Jermaine Smith, medical.
All right, it's case 2021 CF 8899 AO. Mr. Jermaine Smith, going to appoint a public defender to represent him.
I'll waive the appearance, Your Honor.
All right, he's here on charges of criminal mischief, felony criminal mischief, and battery on a person 65 years or older. Did review the charging affidavit in his case, did find probable cause for his arrest. Going to say his bonds are set amount of $1,500, $2,500. Condition of the bond, no return to the scene of the location, no contact with any victims or witnesses, may not possess any weapons or firearms. The weapons or firearms he has needs to be returned over to law enforcement within 24 hours of his release. He's also out on bond in case 2021 CF 5106 AO. Of course, going to revoke that bond, set a new bond at $0 as to that matter. Going to appoint a public defender to represent him in all cases he's not already appointed or don't already have representation. Have a great day. All right. Here we go. Afternoon, sir. Can you tell me your name?
Sidney M. Swope III.
Mr. Swope, you're here in case 2021 CF 8317 AO on charge of exploitation of the elderly in 2 counts and grand theft of the first degree of $100,000 or more. Judge signing your warrant in this case has already found probable cause for your arrest. Set your bond in count 1 amount $250,000. Count 2, $50,000. Count 3, $50,000. Condition of the bond, you had no contact with the victim in this case or any other witness.
Your Honor, he does qualify for pretrial release. Would you consider lowering count 1 and placing him on pretrial release?
Nope. Judge is kind to him in this matter. All right. So they're saying no contact. Got me?
Yes, sir.
Don't violate this order.
Yes, Your Honor.
You have no contact. You come back here in front of me
Yes, Your Honor.
or in front of the judge that assigns this case, we're going to be some real issues at that point, okay?
Yes, Your Honor.
All right, have a great day, sir.
Does he qualify for the public defender, Your Honor?
I think I appointed him to public defender, correct? No, I'm going to give you the public defender to represent you in this matter. You want the public defender to represent you?
At this time, yes, Your Honor.
Yep, then you'll have the public defender until you can get your own attorney. Have a great day.
Vera?